The Subcommittee on Elections of the Committee on House Administration will now come to order. Let me say good morning to all of you and thank you so very much for joining us today. I'm told that the Committee on the Judiciary met until 5 o'clock this morning, and so Ms. Scanlon may be a little late arriving today, and when she does arrive, I'm going to accelerate her statement and let her go as early as we possibly can. As I said, the Judiciary Committee worked until 5 o'clock this morning, and I'm told that they will resume their work at 11 o'clock this morning, Eastern Time. And so as we begin, colleagues, this morning, I want to note we are holding this hearing in a hybrid fashion. It's an in-person hearing, and we're doing it remotely. And we're also doing it in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. Generally, we ask any committee members and witnesses who are joining us remotely to keep their microphones muted when they are not speaking. And the purpose of this is to limit background noise. Members will need to unmute themselves when seeking recognition or when recognized for their 5 minutes. Witnesses will also need to unmute themselves when recognized for their 5 minutes or when answering a question. If you're joining us remotely, thank you for doing so this morning. But please keep in mind that your camera must be on at all times, even if you need to step away for a moment. Please do not leave the meeting or turn your camera off. There are good technical reasons for that, but those are the rules. Lastly, for those who are joining in person, we are holding this hearing in compliance with the guidance issued by the Office of the Attending Physician, and anyone joining us in the hearing room who is not vaccinated should continue to please wear your mask. At this time, I will ask unanimous consent that the chair be authorized to declare a recess of this subcommittee at any point, and that all members have 5 legislative days in which to revise and extend their remarks and have any written statements be made part of the record. I hear no objections. It is therefore ordered. Today's hearing, ladies and gentlemen, is the 5th, number 5. It is the 5th in our subcommittee series examining voting in America. Today, we will discuss changes in election administration and voting laws that change methods of election, alter jurisdictional boundaries, and redraw district lines, as well as a national perspective on the state of the right to vote in our great country. As we sit here today, it cannot go unacknowledged that tomorrow is the 8th anniversary of the Supreme Court's decision in Shelby County versus Holder, a case that we're all familiar with, a decision that reshaped the landscape of voting rights and protecting the right to vote in this country. This decision opened the door to a wave of suppressive voting measures that are no longer subject to a review by the Department of Justice for its discriminatory impact. Since that decision, the Shelby decision, access to the ballot has been under constant attack, sometimes overtly through direct attacks on opportunities to vote, as we discussed at previous hearings, discriminatory voter ID laws, changes to polling locations that can disenfranchise minority voters and lead to long wait lines and lack of access to language materials. Sometimes these attacks are less overt, like moving district lines or changing election procedures under the guise of election integrity. The evidence and data this subcommittee has heard so far, and we've collected through these hearings, it seems to me to be undeniable. The changes to election laws and procedures we have discussed can and are enacted and administered in a discriminatory manner. As I said when we began this series of hearings, one of our most sacred rights in this country is the absolute right to vote. However, as the evidence has shown, access to the ballot in this country is not, and it has not been, free nor fair for all eligible voters. I'm not just talking about voters on one side of the political persuasion, but all eligible voters. 8 years after the Supreme Court decided Shelby, our work continues. As our dear friend and my dear friend and former colleague, the late Congressman John Lewis, often said, the vote is precious. John would tell us in our caucus meetings, it's almost sacred. And so we can, and we must do better. The testimony provided today will be informative as we seek to understand what needs to be done to safeguard our elections and guarantee equal access to the ballot box. We must, colleagues, we must comply with the Supreme Court's directive that we create a new formula. Section 4, we call it, a new formula, narrowly tailored to meet current conditions. We have seen in other hearings that a law which is neutral on its face, or at least appears to be neutral on its face, can actually violate Section 5, which is still the law of the land. I remind you, the Supreme Court did not strike down Section 5. It found Section 4, the formula, to be unconstitutional. If the law disproportionately and materially burdens minority voters when measured against pre-existing state law, then it violates Section 5. I want to repeat that, and then I'm going to close, because so many of my colleagues, not on this committee, but throughout the House and the Senate, many of our colleagues really don't fully understand and appreciate this. If a law, a new law, disproportionately and materially burdens minority voters when it is measured against pre-existing state law, then it violates Section 5. And so with that said, Mr. Ranking Member, I look forward to hearing from today's witnesses. I will continue to work with my colleagues to protect this sacred right. It is now my pleasure to recognize the Ranking Member, and I can now honestly say my friend, Mr. Stile, for any opening statements that he might have.
Thank you, Mr. Chairman. Earlier this week, H.R. 1 S1 failed to advance in the Senate. H.R. 1 and S1 would have created the first ever public financing of congressional campaigns. It would have gutted voter ID laws. It would have legalized ballot harvesting nationwide. It would have weaponized the FEC. It would have limited free speech protections for Americans, and it would have nationalized our elections. Luckily, the bill failed to achieve 60 votes in the United States Senate. When Democratic Senator Joe Manchin announced his opposition to H.R. 1 and S1, he wrote, quote, "Partisan voting legislation will destroy the already weakening binds of our democracy," end quote. He was chastised when he said that by the left. One of our Democratic colleagues from the New York delegation said Manchin's op-ed might as well have been titled, quote, "Why I'll Vote to Preserve Jim Crow," end quote. Unfortunately, this isn't the first time we've heard this kind of ridiculous rhetoric, disinformation, and scare tactics about many of the election integrity laws states have in place or are passing to make it easy to vote, but hard to cheat. We heard the same rhetoric in my home state of Wisconsin when the state implemented voter ID. But in practice, this is not the case. The 2020 election, almost 76% of eligible voters cast a ballot, the fourth highest rate in the country. Another member of the New York delegation recently described states' efforts to bolster voter confidence through smart reforms as, quote, "voter suppression epidemic," end quote, on CNN's State of the Union. And President Joe Biden called Georgia's law, quote, "un-American, sick, and Jim Crow on steroids," end quote. Eventually, that earned him 4 Pinocchios in the Washington Post. When you take the time to read the legislation and analyze these state laws, you'll find that many states' Democrats are crying wolf about actually having less restrictive voting laws than many democratically controlled states such as New York or Delaware. However, it just doesn't fit their narrative. It's all part of an effort to convince the American people that the laws being passed by states are so racist or suppressive that the only option is for the great benevolent federal government to take over. This is a dangerous and false narrative. I'm thankful that our country has come a long way since the passage of the Voting Rights Act of 1965. It's important to recognize. It's also important to remember the history behind the need for that legislation, which was intended to protect and promote minority voter registration and turnout, a moral and just goal. Our colleague, Congressman Burgess Owens, testified about this at the Senate hearing on H.R. 1 and S1, sharing his experience with Jim Crow laws growing up in the Deep South, and noting how dangerous it is to spread the false narrative that Jim Crow laws are being implemented today. Congressman Owens stated in his testimony, quote, "It's disgusting and offensive to compare the actual voter suppression and violence of the era that we grew up in with a state law that only asks people to show their ID," end quote. While Senate Republicans may have stopped H.R. 1 and S1, this committee hearing today is proof that Democratic efforts to nationalize our elections is far from over. House and Senate Democrats turn their attention to pass H.R. 4, we need to examine the power of the voting section of the Civil Rights Division of the Justice Department, which Democrats wish to expand. For example, if H.R. 4, as written last Congress, were to become law, the state of Wisconsin would need to get pre-clearance from unelected bureaucrats in Washington to implement common sense voter ID laws. H.R. 4 would essentially remove states' constitutional authority to run their own elections. With the failure of H.R. 1, make no mistake, H.R. 4 is Democrats' next attempt to take at a federal takeover of our election system. Although unrelated to today's hearing, I just want to quickly mention something that happened in our hearing that was very concerning at our last hearing that was concerning about the use of Zuckerbucks in election administration. Mark Zuckerberg poured more than $350 million into the supposedly nonpartisan nonprofit to help election administrators across the country conduct elections during the pandemic. However, the Foundation for Government Accountability found that much of these dollars went into heavily Democratic areas. For example, the research found that 92% of the funding in Pennsylvania went to counties that broke in favor of President Biden. In another example in Wisconsin, they found that $9.6 million that went into Wisconsin, $7.5 million of that went into just 5 cities, the cities of Milwaukee, Madison, Green Bay, Kenosha, and Racine, heavily Democratic areas. This amount of private money going to influence the administration of our elections is concerning, and I believe it's something that this committee should take up and examine. With that, Mr. Chairman, I look forward to today's discussion, and I yield back.
The gentleman yields back, and I thank you, Mr. Ranking Member, for your comments, and thank you for all that you do for this committee and for your constituents. In your opening statement, you made reference to my friend and your friend, Senator Manchin, and thank you very much for those kind words about Senator Manchin. He is indeed a principled and thoughtful United States Senator. I recall the senator making a statement about H.R. 1, and my recollection is that he does not disagree with H.R. 1. He disagrees with certain portions of H.R. 1, but he published a statement of the things that he agreed with and would be willing to support. And also, Senator Manchin supports updating the formula. We have some differences of opinion about how it should be done, but Senator Manchin is on record in support of reauthorizing Section 4. With that in mind, let me recognize the ranking member of the full committee, Mr. Davis, Rodney Davis of Illinois.
Thank you, Mr. Chair. It's great to see you. I appreciate another opportunity to talk about these very important issues. Considering the important nature of this hearing, I'm actually pleased to hear from the National Republican Redistricting Trust and ask unanimous consent, Mr. Chair, that their testimony be entered into the record. You know, we know this is a majority-driven institution, and the majority gets to pick a lot more witnesses than what we do. So this gives us a chance to get some other witness testimony into the record, because we all know the Democrats are holding this hearing to develop a new pre-clearance formula. The Supreme Court struck down as unconstitutional the old formula. That old formula looked at primarily minority voting registration and turnout, subjecting underperforming jurisdictions to pre-clearance, an extreme remedy that allowed a federal court or the Federal Department of Justice to prevent a state law or a municipal ordinance from going into effect. And our ranking member, Mr. Stile, laid this out very effectively just a few minutes ago. Thankfully, that extreme remedy is no longer required. Minority voter turnout has hit record levels, and minority voter registration is also high. We still have some work to do, but nothing rises to the level of requiring pre-clearance, a direct affront on state sovereignty and equal dignity. When it comes to redistricting, states must maintain the authority to determine the best methods for their own citizens, which may rely on maps drawn by the legislature or a commission. However, I can tell you, as somebody who lives in the state of Illinois, I am for independent commissions. I think the process has been corrupted by politicians from both sides. I'm pleased that many Democrats appear to be coming around to voter ID, a highly popular policy that's important for supporting voter confidence in our election processes and their outcomes. Even Stacey Abrams and President Carter approved of voter ID. Finally, we must ensure that we remove any federal policies that serve as improper impediments to Native American participation in federal elections. And Mr. Chair, thanks for the opportunity to offer opening comments. I yield back.
And thank you, Mr. Davis, for your words. At this time, I'm going to introduce today's first panel, but before I do that, as a reminder to our witnesses, each of you will be recognized for 5 minutes. For those who are appearing virtually, there is a timer on your screen. Look right up there and you will see the timer. Please be sure that you can see the timer and are mindful of the 5-minute time limit. For those who are joining us in person, there is a lighting system and timer in front of you. Please be mindful of the lights and the 5-minute limit. Your entire written statements will be made part of the record, and the record will remain open for at least 5 days for additional materials to be submitted. Welcome to each of our witnesses today. Joining us today on our first panel are Gerry Guatemala. Gerry is of the Asian American Legal Defense and Education Fund. Also, Patty Ferguson-Bonet, and if I'm mispronouncing any of these names, please forgive me. I am from Eastern North Carolina. Patty Ferguson-Bonet of the Indian Legal Clinic at the Sandra Day O'Connor College of Law. We also have Mr. Eric H. Holder, Jr. of the National Democratic Redistricting Committee. And as we all know, he is the former Attorney General. And Thor Hearn of the True North Law Group. Next, we will now recognize Gerry Guatemala. Well, let me introduce Gerry Guatemala in more detail. He is the director of the Democracy Program at the Asian American Legal Defense and Education Fund. He has worked in election protection on behalf of Asian American voters, litigated and testified on redistricting issues. He has litigated cases concerning violations of sections 203 and 208 of the Voting Rights Act. He is also an adjunct professor of law at New York Law School. Next is Patty Ferguson-Bonet. She is the director of the Indian Legal Clinic at the Sandra Day O'Connor College of Law at Arizona State University, ASU. She is also a clinical professor of law, the faculty director of the Indian Legal Program. She has substantial experience in Indian law, and that's something this committee on both sides of the aisle we are all concerned about, election law and policy matters, and she also concentrates on voting rights. She also testified before this subcommittee twice. Last Congress, I remember it well, on issues impacting access to the ballot for Native American voters. She is a member of the Port Ashin, and I'm mispronouncing that, I'm sorry, Indian tribe, and serves as the Native Vote Election Protection Coordinator for the state of Arizona. Mr. Eric H. Holder, Jr. is the former Attorney General of the United States. He serves as the chairman of the National Democratic Redistricting Committee. General Holder served in the Obama administration as Attorney General of the United States from 2009 to 2015, the third longest serving Attorney General in U.S. history, and the first African American to hold that office, also with relatives in Raleigh, North Carolina. I might say that. Next is Thor Hearn II. Thor is a founding partner of True North Law Group and has worked in federal and state litigation and appeals in matters involving property rights, constitutional law, and election issues. Mr. Hearn has argued cases before the U.S. Supreme Court, the Circuit Courts of Appeals, and various state Supreme Courts. He served as President Bush's National Election Council. In the 2004 campaign, was an advisor to the Carter-Baker Commission on Federal Election Reform. That concludes my introductions. I will now recognize the witnesses, each for 5 minutes. Mr. Guatemala, you're recognized.
Thank you, Mr. Chair. Thank you, Ranking Member, and thank you to the committee for allowing ALDEF, the Asian American Legal Defense and Education Fund, to testify and put forth the perspective of Asian American voters, a perspective that is often not included. We conduct our Asian American exit poll and poll monitoring program every major election. We've done this since 1988. In 2020, for the presidential election, we were in 13 states in Washington, D.C., and had interactions with over 5,000 Asian American voters. In our work, we do focus on the language access provisions of the Voting Rights Act, sections 203 and 208. These violations are ongoing. In 2015, we sued the state of Texas for violating Section 208. And just a few weeks ago, on June 3rd, we filed a Section 203 complaint against Hamtramck, Michigan, for not providing Bengali language assistance. We also do a lot of work on redistricting. As you see in the materials that we submitted, in the last redistricting cycle, in Favors v. Cuomo, a redistricting case out of New York State, we submitted several documents, a memo, as well as some attachments. And one of those attachments is what we call Asian American Communities of Interest, the neighborhood maps of 15 Asian American communities of interest in New York City. The way we constructed that map, those 15 different maps, we met with community groups and we asked them to identify their own neighborhood boundaries. That's what we submitted, and on the last 3 pages of that document, we superimposed those 15 different Asian American communities of interest over the then existing assembly lines, state Senate lines, and congressional lines. And what we found was that every single Asian American community of interest was divided into numerous different legislative districts. And what this does is it prevents Asian American voters from electing a candidate of their choice. And it's not a coincidence why, with a population of over 1 million Asian Americans, which would be the 10th largest city in the United States, Asian Americans had very little electoral success in New York City without fair redistricting. Indeed, at the time of the last redistricting cycle, there was never an Asian American elected to Congress from New York State, nor did we have an Asian American elected to the state Senate. Several Asian American communities of interest were divided into as many as 6 different legislative districts. Again, this denies this community, our community, the opportunity to elect a candidate of its choice. We had to litigate in federal court to argue that these communities of interest should be kept whole and together. The court actually agreed with us, and at the congressional level, drew a congressional district that kept Asian American communities of interest together. It was centered in Flushing, Queens, where there's a large concentration of Asian American residents. And for the very first time, just several months later, New York elected the first ever Asian American to Congress from New York State. We do this redistricting work all around the country. We're in Boston, we're in Pennsylvania, New Jersey, as well as Texas. People don't realize Section 5, we did have coverage in New York. It's not only in the South, we had 3 counties that were covered under Section 5, which helped us in Section 203 compliance. It also helped us in the redistricting process. We worked with the Black community and the Latino community in forming what we call a unity map that protected all the communities of color that were protected under the Voting Rights Act. It was very powerful to have that knowledge that Section 5 was there, and the people that were drawing the map, the legislature, they started from that position of making sure that they were complying with Section 5 and not retrogressing districts that were performing for communities of color, which is very important. And we don't have it. It's the first redistricting cycle in several decades, 50 years, where we're not going to have this pre-clearance protection. And in a place like Texas, we know that's essential because of the few Asian Americans that are elected in Texas. We know there has been consistent efforts to deconstruct and divide their communities. Hubert Rowe, it's in my materials. We submitted an amicus brief in the last redistricting cycle. He's the first ever Vietnamese American elected to the Texas State House. His victory was challenged. There were racist comments and accusations made about the voters in his district. He's in a tri-racial coalition district where Blacks, Latinos, and Asian Americans all vote as a bloc to elect Mr. Rowe. In the last round, his district was dismantled, and only because of Section 5 was his district protected, and the new redistricting plan kept his district intact. We do need help from the Department of Justice. We're very
Close out, if you will, sir.
upset that, we're very upset to see very little action, really no action from the Department of Justice. We need their help in protecting Asian American voters, and we need Section 5 back. Those few protections that we had is very effective in protecting Asian American voters, and we look forward to working with this committee and making sure that happens. Thank you.
Thank you, Mr. Guatemala. At this time, the chair recognizes Professor Ferguson Bonet. You are now recognized for 5 minutes.
Good morning, Chairman Butterfield, Ranking Member Style, Ranking Member Davis, and members of the committee. Thank you for inviting me to testify today. The Indian Legal Clinic coordinates the Arizona Native Vote Election Protection Project, a nonpartisan effort to protect Native American voting rights. On behalf of tribal clients, I have litigated Section 2 cases involving redistricting, restrictive voting laws, early voting access, and language compliance under Section 203. After Congress passed the Indian Citizenship Act of 1924, states with large Native American populations created legal barriers to prevent Natives from registering to vote and casting a ballot. 4 decades later, the Voting Rights Act finally opened the door for Native Americans to exercise the right to vote. This led to efforts by local and state lawmakers to reduce the effectiveness of the Native vote and to prevent Native Americans from being elected to office. States and their political subdivisions have used the redistricting process to disenfranchise Native American communities, especially in areas with significant Native populations that can determine the outcome of elections. Not surprisingly, non-Indians have manipulated the redistricting process in order to maintain power and control. Before Shelby County, the Department of Justice issued 9 Section 5 objections to redistricting plans involving Native voters in Alaska, Arizona, and South Dakota, and 5 of these were in Arizona. The Department of Justice also brought numerous redistricting cases to enforce voting rights of Native Americans between the 1970s and 2000. In the past 2 decades, however, most redistricting litigation filed on behalf of Indian voters has been brought by tribes and private parties. Since 1996, 22 federal cases challenging at-large election systems, redistricting lines, or malapportionment have been filed on behalf of Native voters involving state legislative districts, school boards, counties, sanitation districts, and city councils. Packing has been one of the methods used to reduce voting strength. Multiple counties in South Dakota have packed Native Americans in the fewest number of districts, thereby eliminating their ability to elect multiple candidates of choice. In San Juan County, Utah, the county placed Navajo voters in a single overpopulated district so that they would not have the ability to elect more than 1 member to the 3-person county commission. Plaintiffs spent $3.4 million over 7 years to litigate this case. And in the last 25 years, jurisdictions in Montana, North Dakota, South Dakota, and Wyoming have used at-large voting schemes to disenfranchise Native Americans. Also, geographic and jurisdictional boundaries frustrate the ability of many tribal communities to politically mobilize in support of one candidate for many federal, state, and local offices because a reservation may be split among multiple districts, counties, or even states. Over 200 reservations are located in multiple counties or states. Some jurisdictions fail to respect tribal boundaries when creating districts. Redistricting bodies in Wisconsin, Montana, Washington, and California have diluted the power of tribal communities by dividing tribal voters among multiple districts. In Washington, for example, the Lummi, Colville, and Yakima reservations were each split into multiple districts. Arizona courts have invalidated redistricting plans when the state legislature split tribal reservations into multiple districts. In addition to redistricting boundaries, precinct lines can cause confusion and result in discarded ballots. In Arizona, sometimes counties fail to place a voter in the correct precinct, or counties create precinct lines that divide a tribal community. Not only does this cause confusion, but Native voters are more likely to have their ballot discarded for voting at the wrong polling location. But for discriminatory practices, Native Americans would have greater representation in local, state, and national decision-making efforts that affect their lives. Despite barriers, Natives continue to fight to protect and exercise the right to vote. However, past redistricting and jurisdictional issues have stunted the full potential of the Native vote. Redistricting provides an opportunity to reverse course and ensure Native American representation. As Justice Breyer said in Shelby County, "It's an old disease, it's gotten a lot better, but it's still there." I'd like to remind the committee that Congress has a duty to fulfill its unique trust obligation to Native Americans, including in the matters of voting. This must include a meaningful opportunity for Native people to elect candidates of choice, be heard, and not be saddled by unnecessary barriers that exploit centuries worth of inequality. We need robust voting rights legislation to mitigate the burden placed on tribes to litigate Section 2 cases, and the Department of Justice can carry out this trust responsibility by bringing enforcement actions to protect Native American voters. Thank you for the opportunity to testify. I'm happy to answer any questions the committee may have.
And thank you for your testimony. At this time, the chair recognizes Attorney General Holder for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Stile, Mr. Davis, and members of the committee. I want to thank you for the opportunity to appear before you today. As you know, we're having this important conversation at a very important moment. 8 years ago tomorrow, in the Shelby County decision, a very divided Supreme Court gutted Section 5 of the Voting Rights Act of 1965 and undermined a cornerstone of American democracy protection. Now, before 2013, Section 5, relying on Section 4, had helped prevent discriminatory voting laws from taking effect by imposing preclearance protections that required a federal review of changes to voting procedures in covered regions. Basically, areas with a history of discrimination had to get approval from the Department of Justice or from a federal court for significant changes in voting laws or procedures. Now, that section of the Voting Rights Act had helped to stop some of the worst attempts to discriminate against minority voters for decades. But in a 5-4 opinion, the conservative members of the court wrote that the nation had changed dramatically since the Voting Rights Act went into effect, and that because of gains made, particularly by Black Americans, these protections were no longer necessary. They were wrong. Efforts to keep groups of Americans, particularly African Americans, away from the ballot box were as old as America itself, and the same forces that have historically sought to create an unequal status quo are still working to impose it today. In the days since that ruling 8 years ago, unnecessary and discriminatory voting restrictions went up across the country. We saw state legislatures pass a rash of strict voter ID laws that disproportionately impacted people of color. We saw voting roll purges and poll closures targeting minority and poor communities. And we saw newly emboldened state legislatures draw discriminatory maps that unfairly placed Black people and other people of color, young and poor people, into gerrymandered voting districts where their impact would be diluted and their voice ultimately lost. Now, as Attorney General, I fought back against these attempts to subvert our democracy and to disenfranchise voters of color using the remaining provisions of the Voting Rights Act in cases from Texas, North Carolina, and Ohio to Wisconsin, Montana, and South Dakota. As chair of the National Democratic Redistricting Committee, I've continued that work, taking on unfair maps, fighting for fair elections, and demanding justice for every American voter across the country. But just as my work has continued, so too often have efforts to roll back the clock on voting rights. Over the past few years, politicians have used a range of strategies to diminish the voice of the people, from gerrymandering to voter suppression to outright intimidation. And today, we're facing what I would call a sustained, coordinated, multi-pronged assault that seeks to diminish protections for voters, restrict access to the franchise, and redefine the way that power is gained and exercised in the United States of America. We have seen this assault in voting restrictions, voter ID laws, and voter roll purges that have unfairly, and in some cases illegally, stripped Americans of their rights. In just the first 6 months of 2021, state legislatures across the country have introduced more than 389 bills in 48 states that would make it harder to cast a ballot. 24 have already been passed into law. Since the Shelby County decision, millions of Americans have unnecessarily been purged from voter rolls. Nearly 1,700 polling locations have been closed since the decision. We have seen map manipulation and gerrymandering that has allowed politicians to pick their voters so that a party with minority views and minority support can illegitimately govern with majority power. In states that are politically competitive, like Pennsylvania, North Carolina, and Wisconsin, one party has sought to draw lines with surgical precision, packing some voters together and splitting other towns and communities apart in order to create congressional delegations and state legislatures that are heavily skewed on a partisan basis and immune to citizen accountability. And we've seen in the Supreme Court decision in Rucho that abandon the court's fundamental and I think unique responsibility to achieve justice in the face of partisan gerrymandering. Now, these actions have not made our elections safer or more secure. They've not improved the quality or the accessibility of our politics. Instead, they have stripped Americans of fundamental rights and undermined the promise of American democracy. And they've all, every one of them, disproportionately impacted people of color. Just a few weeks ago, more than 100 of our nation's top democracy scholars signed a letter warning about the deterioration of American voting rights and representation due to radical laws, regulations, and restrictions imposed over the last few months. As a result of these changes, they said voting procedures in some states, quote, no longer meet the minimum conditions for free and fair elections, unquote. In the United States, our beloved country, this must not stand. We need to repair the damage being done to our democracy. We need to create lasting, durable safeguards to protect our most essential freedom. We need to expand and codify into law voting rights and processes so that every eligible American casts a ballot and be confident that it will be fairly counted. We need to end gerrymandering so that all people, including people of color, can be represented by public servants of their choice. I am here to do all that I can to help in that regard. I'm not asking for political favoritism. I'm asking for no special treatment for any group or community. I'm asking for nothing more radical than that which is at the heart of the American experiment, the idea at the core of American democracy, free and fair elections where the people, all of the people, are heard and all of the people are respected. Thank you very much.
Thank you, Mr. Holder, for your statement. At this time, the chair will recognize Mr. Hearn for 5 minutes. Mr. Hearn.
Thank you, Chairman Butterfield and Ranking Member Stile and the members of this committee. I appreciate this very important opportunity to appear before you in this hearing on how we conduct elections in our nation. How we conduct our elections is the bedrock of our constitutional republic. Without every voter having the ability to cast a vote and all citizens having confidence in the conduct and outcome of our elections, we the people would cease to govern our nation. I firmly believe that while political campaigns and elections are quintessentially a partisan endeavor, the manner in which elections are conducted and the laws governing the conduct of the election should rise above partisan interests. Our identity as Americans should transcend our partisan affiliation as a Republican or a Democrat. As President Obama said in his speech to the Democrat National Convention in 2004, there's not a liberal America and a conservative America. There is the United States of America. There's not a Black America and a white America and a Latino in America and an Asian America. There's the United States of America. I totally agree. As Americans, we share a common interest in assuring our elections are fair, honest, and accessible to every voter. We also share a common interest in assuring that the outcome reflects the will of the voters and was not engineered by disenfranchising any segment of our population, some voters by partisan manipulation or by manipulation of the election process. Elections must be conducted according to clearly written laws that are faithfully followed and administered by election officials with transparency and without any racial or partisan bias. Every eligible citizen, irrespective of their race, color, or heritage, must have equal opportunity to cast a ballot, and every American must be confident that every lawfully cast ballot was accurately counted. The Voting Rights Act of 1965 was an extraordinary legislative accomplishment because it was adopted in a broad bipartisan manner. The bill was sponsored by Senators Dirksen and Manfield, both the Republican and Democrat leaders of the Senate, and it was passed on a bipartisan basis. That is one of the most important points for the moral authority of the Civil Rights Act, and more recently, the Carter-Baker Commission provided a high water mark in bipartisan election reform and made a number of recommendations to increase our nation's confidence in the outcome of our election and also to increase voter participation in our elections. This recommendations included a reliable, accessible voter identification requirement, elimination of ballot harvesting, maintenance of current and accurate voter rolls, among other reforms that increase voter confidence and increase voter participation. These recommendations were broadly supported by bipartisan members of the Carter-Baker Commission, and they are the basis for recommendations this committee and other state and local election jurisdictions should consider. These recommendations will increase voter confidence in our elections and increase voter participation. I return to my central point. Laws governing the conduct of our election should be broadly bipartisan, not an effort to achieve a partisan advantage for one or the other side. At the end of the day, we are all Americans, and we all have our first allegiance to our nation. And it's not to a party or to a particular partisan ideology. And we need to work together to do that and have the moral authority of an election conduct that is bipartisan and rises above any particular effort to game the system for one or another faction. I commend again the work of the Carter-Baker Commission, and I will welcome any questions when we get to that point. Thank you.
And thank you, Mr. Hearn, for your testimony. That concludes the statements from the witnesses. I think it may be time now for us to move to member questions. I'm going to take Ms. Scanlon first. Very gay. I understand that you may have been in markup very late last night, maybe to 5 o'clock this morning.
Yes, it was.
Well, we're gonna make you first. You know, I've participated in an all-night markup before, and it's very brutal. I think my other committee, the Committee on Energy and Commerce, probably holds the record for the longest markup, some 25 or 26 hours. So I'm empathizing with your position. So at this time, you're recognized for 5 minutes.
Thank you, Chairman Butterfield, and thank you to our witnesses. You know, in Pennsylvania, we've lived with the reality of political gerrymandering. I've lived in the same house for 26 years, and I've been in 3 different congressional districts. In 2018, after a special election, I briefly served as the representative for Pennsylvania's 7th district, which had been dubbed Goofy Kicking Donald based on its cartoonish shape. It snaked across 6 counties and halfway across the length and breadth of the state to collect voters to form a district with a Republican voter majority in a region that had a Democratic voter registration majority. At one point, that district was only the width of a restaurant. For the better part of the 2010 decade, Republicans controlled 13 of Pennsylvania's 18 congressional seats through gerrymandering, despite the fact that Democrats held a statewide voter registration edge of several hundred thousand. In 2018, as a result of a lawsuit brought by the League of Women Voters, Pennsylvania's congressional districts were declared so gerrymandered as to be an unconstitutional denial of the right to vote. Pennsylvania state law still provides for redistricting to occur by legislation, and there's every reason to believe the Republican-controlled legislature will abuse this power again when it redistricts the Commonwealth later this year to reflect the loss of a congressional seat. An effort to amend the state constitution to substitute a redistricting commission for the current partisan process was guttered by those same legislators just a year or so ago. Without congressional intervention, we'll continue to see politicians crack and pack districts to their benefit. I want to take a moment to address some of the false claims being pushed about the voter legislation, H.R. 1 and the John Lewis Voting Rights Act. These bills are absolutely necessary as we see a concerted effort by Republican legislatures across the country to make it harder to vote and easier to overthrow elections. First of all, this is not a federal takeover of the election process. Article 1, Section 4 of the Constitution empowers Congress to regulate federal elections. Second, H.R. 1 and the Voting Rights Act do not outlaw voter ID. All states require some form of voter ID in registration or the voting process. What these laws do is outlaw voter ID laws that preference some voters over others. A classic example is the Texas statute, which recognized voters with a gun license, but not with a student ID. Third, although I can't read my own writing because it disintegrated last night. Although Republican legislatures over the past several decades have led the way to implement no-excuse mail-in voting, including a law that was passed before COVID in Pennsylvania, that changed in 2020 when former President Trump began, without evidence, to malign the use of mail-in ballots. I want to make clear, mail-in ballots are secure. They have multiple levels of security. They have been used by our military since the Civil War, and there is no evidence of widespread fraud. To the contrary, mail-in voting was a blessing during the pandemic. For our witnesses, thank you so much for being here today. Mr. Holder, we last met coordinating election protection efforts in the Philadelphia region in 2008. You discussed Shelby, in which Justice Roberts invited Congress to update its response, the preclearance sections to respond to modern conditions. I happen to agree with the late Justice Ruth Bader Ginsburg, who dissented in that case, saying that preclearance was in fact working, and throwing it away was like throwing away an umbrella in a storm because you're not getting wet. Since Shelby, voter suppression efforts have metastasized across the country in new forms. As one of my colleagues from Pennsylvania, Malcolm Kenyatta, recently said, we now have artisanal voter suppression. Can you talk a little bit about what we should be doing with respect to reauthorizing the preclearance provisions?
Yeah, I think we certainly have to respond to the findings of the Shelby County decision, holding hearings like this, creating a record that shows the impact of the Shelby decision, 1,700 polling place closures, unnecessary voter purges, to establish a record for congressional action. The court in the Shelby decision actually invited congressional action, and I think the efforts that are being led by Chairman Butterfield here are consistent with what the Shelby County decision mandated. I think that the Congress, through the necessary work and making appropriate findings, can craft legislation that would be responsive to the concerns expressed by 5 members of the court, and come up with a new system that in fact would pass constitutional muster.
Thank you. Mr.
Gentlelady's time has expired. You can make this your last question if you can.
Actually, I would just seek unanimous consent to enter into the record the testimony of Kristen Clark, now Assistant Attorney General of the Civil Rights Division, when she testified before the House Judiciary Committee, Subcommittee on Constitution, Civil Rights, and Civil Liberties in 2019, outlining the dozens, if not hundreds, of voter suppression acts that had occurred since the Shelby decision. And with that, I yield back. Thank you.
Statement of the Assistant Attorney General, Ms. Clark, will be received unless there is objection. Hearing no objection, it will be received. At this time, the chair is pleased to recognize the ranking member of the subcommittee, Mr. Stile.
Thank you, Mr. Chairman, and thank you to our panelists for being here this morning. Mr. Hearn, in your testimony, you stated that you served as an advisor on the Commission on Federal Election Reform, commonly known as the Carter-Baker Commission. The commission made a total of 87 election reform recommendations to increase voter confidence in the election process following the 2000 presidential election. And most notable was the commission's endorsement of a photo identification requirement to vote. How many members served on the Carter-Baker Commission, Mr. Hearn? Mr. Hearn? The pros, cons of an electronic hybrid. I'll answer the question. It's 21. 21 commissioners. Are you there, Mr. Hearn?
Yes, I am. I am here. Is it there? Sorry, Member Stiles.
That's fine. There were 21 commissioners on the Carter-Baker Commission. It was bipartisan, Republicans and Democrats, correct?
That is correct. It included luminaries from this body like Lee Hamilton, Bob Michael, obviously President Carter, and Secretary Baker.
And how many members voted in support of the voter ID recommendation?
They all voted in support of it except for 2 members, Tom Daschle and Spencer Overton, who filed a supplemental statement in which they said they didn't support the use of the federal real ID as an identification.
So in summary, Democrats and Republicans on that commission in 2000, looking to increase voter confidence in the election, voted in favor of photo ID. Let me shift gears here slightly. I think one thing we can all agree on is that voting rights are important and that every single eligible person who wants to vote should have the opportunity to cast a ballot, and that every vote should be counted according to state law. And thankfully, our country's come a long way since the 1960s. And so I'd like to dive into the preclearance, which is really an extreme legal remedy. As Mr. Holder, as you're aware, in 2013, the United States Supreme Court declared the preclearance coverage formula unconstitutional in Shelby County because the criteria used were outdated and therefore violated principles of equal state sovereignty and federalism. And so the preclearance formula in the Voting Rights Act was based on 1965 election information, which had low turnout rates, in particular among minority voters. If a new preclearance formula was introduced, what would be your specific criteria to identify a covered jurisdiction?
Well, I think that what we'd have to do is do what the Congress did back in 1965, which is to conduct hearings as you're doing now, come up with ways in which you look at states that have
you're uniquely knowledgeable. You sit on a board, you study this. What would be the specific criteria that you would recommend Congress look at to determine who would be covered?
Well, I'd look at voter participation. I'd look at the way in which lines were drawn when it comes to gerrymandering, and gerrymandering has has an impact on this whole question of keeping people away from the polls. If we look at the poll closures, 1,700 since Shelby County, 750 in Texas, 320 in Arizona, 200.
So I'm going to reclaim my time. I'm going to reclaim my time just because we're so tight on time here. So I appreciate that. Let me share my concern. Is that I don't know that how jurisdictions are going to know exactly whether or not they're in or out of this preclearance. And my concern is that every jurisdiction is going to find themselves under the role of the federal government, of continuing this push towards a federal government takeover of our elections. That's my concern. And Chief Justice Roberts noted that the Department of Justice is quote, famously opaque, and usually the states and municipalities have to go through or had to go through several layers of back and forth. It's sort of a bargaining process, end quote. So to me, my concern is that the Department of Justice is not going to be impartial. And in 2013, the Department of Justice Inspector General reviewed the DOJ hiring process and determined that 8 of the 9 new hires to the voting rights section had 1 or more liberal affiliations, and 2 of them had an affiliation with the Democratic Party itself. 5 of the hires had affiliation with 5 specific civil rights groups. 2 of the groups are providing testimony today. The IG also noted that none of the 10 candidates had conservative or Republican affiliations that were hired, and only 1 of 235 candidates with unknown affiliations was hired. But the observations of the DOJ hiring practice focused on specific partisan ideological affiliations. I'm concerned that states won't get a fair shake. And Mr. Holder, I know that in your testimony, you noted that you're not asking for favoritism towards any political party, but the group that you represent, the National Democratic Redistricting Committee, in their IRS filing, stated that the purpose of the organization is to build a comprehensive plan to favorably position Democrats for the redistricting process through 2022. Is that correct?
Yeah, to favorably place Democrats in a position to fight for fairness, and make sure that the process is indeed fair. We have to make sure that Democrats have the capacity to be on equal basis with their Republican opponents.
Understood. I think it's important to note the purpose of the organization that you represent. And Mr. Chairman, I'll wrap up by seeking unanimous consent to submit to the record Mr. Holder's organization's IRS filing with that purpose so stated.
Without objection.
Let me just say that is a mischaracterization of the intent of that filing. And beyond that, the notion that the Justice Department has conducted itself
saying that you unfairly uncharacterized yourself in your own IRS filing, that you misfiled.
You are unfairly characterizing that which we wrote. And and beyond that,
I'm not mischaracterizing anything. It says, describe the purpose of the organization. I quoted it in full.
The committee will come to order. As I used to say when I was a trial judge years ago, the witness may complete his answer. All right.
You can look at words and mischaracterize them. With all due respect, Congressman, you're looking at those words and mischaracterizing them. I'm trying to give you their true intention. And beyond that, more importantly, though, this notion that the Justice Department has somehow acted in a partisan way, Republican as well as Democratic attorneys general really enforced the Voting Rights Act during the course of its history. Every president who signed the reauthorization of the Voting Rights Act was, in fact, a Republican. The last reauthorization of the act was supported almost unanimously by Republicans and Democrats in the House as well as in the Senate.
Thank you, Mr. Holder. This time the chair recognizes Mr. Aguilar for 5 minutes.
Thank you, Mr. Chairman. I appreciate it, and I'll do something unique here. I'll ask a question and then let the witnesses answer. Attorney General Holder, for the first time since the 1970s, our nation is entering congressional redistricting cycle without pre-clearance, as Ms. Scanlon mentioned. What does this mean for communities of color who have been disproportionately affected by the drawing of jurisdictional boundaries and already lack representation at the local, state, and federal level?
Well, I'm very concerned about what this will mean. We have seen what state legislatures have done since the Shelby County decision with regard to closing polling places, with regard to, we look at the way in which Republicans gerrymandered in the 2011 process. One of the places, like we're talking about Wisconsin, if you look at in 2018, Democrats got about 54% of the votes for the Wisconsin state legislature, got about 36% of the seats. I am concerned that without the protections of the Voting Rights Act, that which we have seen in the past decade can continue into the following decade and have a negative impact on the ability of the American people to elect representatives who truly represent their policy desires.
After the Shelby ruling, Mr. Attorney General, what's the litigation strategy to fight voter discrimination and disenfranchisement within communities of color?
Well, we bring cases where we can identify racial gerrymanders, and you can bring those into federal court. We've also, after the Rucho decision, brought partisan gerrymandering cases in the state courts using the state constitutions, done so successfully in North Carolina, as has been mentioned, in Pennsylvania as well. And so the Supreme Court rulings have made it difficult for us to bring litigation, but not necessarily impossible.
And the chair talks about this often. Can you talk a little bit about the cost of the litigation and the time that it takes?
Yeah, the preclearance, the beauty of preclearance was that you stopped negative action before it began without the ability to pre-clear in those states that were covered. You have to deal with things that have already occurred, negative impacts that have already occurred, and try to unwind them. And it means that you've probably gone through at least one election cycle where if a finding of impropriety has occurred, at least one election cycle where a process was done inappropriately and probably had a negative impact on the voters in the state or the jurisdiction in which the litigation has been brought.
Thank you, sir. Ms. Ferguson-Bonney, in your written testimony, you mentioned states and local jurisdictions carving up reservations or packing Indian voters in redistricting plans in order to minimize the impact of the native vote, and that this method was called cracking and packing. Can you talk a little bit about how cracking and packing has affected Native Americans, particularly at the local level?
Yes, thank you, Representative Aguilar. We see that there are quite a bit of cracking and packing in local jurisdictions. I think I set forth in my testimony some examples of that. And that has really minimized the Native American voice and the ability to participate. There are also jurisdictions that have added seats on county commissions or judgeships in order to dilute the Native American vote and participation in elections. And when preclearance was in effect in Arizona, for example, there were objections to two submissions from counties that sought to expand the judgeship positions, and in that they found that that would reduce Native American participation. So that has been done really to minimize the Native American voice. And then we see, I just want to give the example of the San Juan Southern Paiute case because you asked about cost. That litigation took 7 years and cost the plaintiffs, which was a tribe, $3.4 million. But these jurisdictions are also spending money to defend their plan. So if they were protected by preclearance, Utah wasn't covered by preclearance before, but if they were protected by preclearance, then a lot of this money would be saved for our local jurisdictions and for the tribes. And most of these tribes do not have the resources to be expending on voting rights litigation.
You said 3.5 years and, I'm sorry, 7 years and $3.5 million?
Yes, yes. And that was really to prevent Native Americans from gaining another seat on the county commission. They were packed, 90% of Native Americans were packed into one district, and the other two districts maintained a lower number of people, so they were malapportioned. And so the Navajo Nation had to file litigation to apportion those districts correctly and to give them an opportunity to elect two candidates of choice, which they did.
Thank you so much. I appreciate that. Mr. Chair, I yield back.
The gentleman yields back. Chair now recognizes the ranking member of the full committee, Mr. Davis.
Thank you, Mr. Chair. As somebody who comes from a state that is completely controlled by one party, the Democrats, they have supermajorities in the House and the Senate. They have a Democratic governor who pledged not to sign a legislative drawn map. He broke that pledge when he recently signed a state legislative map drawn with incomplete census data. I listened to Attorney General Holder's opening comments, and I think, wow, we're going to have a group come in and address the partisan gerrymandering in Illinois. Mr. Holder, I enjoyed your opening comments. We got a chance to meet at the State of the Union one year. I'm glad to see you here again. Can you tell me how recently it's been since you've been to Illinois to discuss partisan gerrymandering?
I have focused on partisan gerrymandering around the country and have stood against Democrats who have engaged in that process, whether it was in the case, the redistricting case, in the Rucho case, standing against what happened in Maryland. I've stood against Democrats in New Jersey and in New York who have tried to use power that they have there to engage in partisan gerrymandering. And I am against partisan and racial gerrymandering done by any party in any place.
Well, I would welcome you to come to my home state of Illinois. I didn't get an answer when the last time you were there to talk about this issue. I do have a quick question regarding this. Does the National Democratic Redistricting Committee support the Mexican American Legal Defense Fund's lawsuit against the state of Illinois for the redistricting plan that was adopted by the Illinois General Assembly just a few weeks ago and signed into law by Governor J.B. Pritzker?
I'll be honest with you, I have not had a chance to review that lawsuit, but I'd be more than glad to do that and submit some supplementary comments with regard to the views of the organization and my personal views on the lawsuit.
I really appreciate that. Also, Illinois' current map was drawn in 2011. There's a lot of discussion here about partisan gerrymandering in 2011. There's a district represented by my good friend and colleague, Mr. Chuy Garcia, that is commonly known as the earmuff district. Would that be an example of Democrats packing minorities into one district?
Again, I'm not familiar with the particular map, but gerrymandering is not something that is only done by Republicans. It has been done by Democrats. We've had gerrymandering almost since the inception of our nation, which doesn't mean we have to accept it. Princeton did a study that said that gerrymandering done by Republicans in 2011 was the worst of the past 50 years. But there are Democratic as well as Republican excesses that I stand against. Let me make that very, very clear.
Well, I appreciate that. And I noticed during the decade, there were remaps drawn only in Republican states. I would, again, welcome your organization to come to my home state of Illinois any year because the Democrats just gerrymandered the state legislative map, and we expect them to do exactly the same thing with the congressional map. So I welcome you and your team to the fight, and I certainly hope that we can communicate in the future on this. Hey, Mr. Holder, General Holder, both the Carter-Baker Commission and the Bauer-Ginsburg Commission established by President Obama identified inaccurate voter rolls as a national problem. And unfortunately, I believe it's still true today. You served, as we know, as AG from 2009 to 2015. And during your tenure at DOJ, how many NVRA Section 8 enforcement actions or investigations did the department bring against states for failure to conduct list maintenance?
I don't have those numbers in front of me, but we certainly took our obligations seriously in that regard.
According to the DOJ website, there were no enforcement actions for failure to conduct list maintenance, only one action against Florida for so-called purging voters. How did you guys know at DOJ during your tenure if a state was in compliance with provisions of the NVRA or not?
Well, we have a variety of techniques. We certainly listen to public comments that we get from a variety of sources. We have investigative components within the Justice Department that are able to monitor situations that are happening around the country. We have a Civil Rights Division, a Voting Rights Section that has investigative power. So the Justice Department has a number of ways in which it can monitor situations around the nation.
I appreciate that, sir. And I know many of your donors to the National Democratic Redistricting Committee may not agree with you wanting to come to states like Illinois, but I certainly appreciate your willingness to talk about these things. Do you support donor disclosure?
I do. I do think that there needs to be transparency with regard to who is making donations to political organizations, and that would be good for our democracy.
Well, sir, will you disclose the donors to the National Democratic Redistricting Committee for the record today?
Well, what we do is follow the law as it exists. I'm not going to unilaterally disarm. When Republicans will do the same thing, I will do that, and we will certainly follow the law. But I stand for the disclosure obligations that are contained in the bills that are being considered for Congress.
Well, I would appreciate any disclosure. Happy to talk with you in the future, sir. Thank you for your responses, and thank you to all the witnesses for being here today.
And we thank you, Mr. Ranking Member. At this time, the chair recognizes Ms. Teresa Fernandez for
Thank-
5 minutes.
Thank you so much, Mr.
Ledger Fernandez.
It is a long name. Thank you so much, Mr. Chair. And, we are here because American democracy really does depend on our power to ensure fair and free elections for all our communities, not just some of our communities, because every citizen, regardless of zip code, has the right to vote without interference and obstruction. Before I came to Congress, I actually represented Native American tribes in redistricting cases and overturned Republican redistricting maps that sought to divide Native American communities. I advocated, the committee included language in H.R. 1 to ensure that independent redistricting commissions respect tribal communities when drawing boundaries. Ms. Ferguson-Boney, based on your experience with regards to Native American voting rights, do you believe that tribes and Native American communities should be protected as communities of interest in the Voting Rights Act?
Thank you very much for the question. I do definitely agree that Native Americans and within their reservation, they should be determined a community of interest. We have seen in some circumstances where redistricting bodies, or those who are making the redistricting decisions, have split tribal boundaries into and tribal reservations into multiple districts, diluting the effectiveness of that vote. We also have tribes who share communities of interest with other tribal people, and that they are communities of interest and have advocated for that, but nonetheless, they have also been split and they've been packed or cracked into different districts. And in that circumstance, there are examples of cracking. I have that in my testimony. I can attach some more specifics for the record if you would like. But I think that's a huge issue, is respecting tribal boundaries and respecting tribal communities of interest. And some redistricting bodies do not do that.
Thank you very much. And for example, in New Mexico, we did include the Pueblos and the Apaches in single districts, legislative districts, precisely because of the fact that they do have affinity on many issues, and that's what they chose. With regards to the independent redistricting commissions, where they exist, have you seen whether there has been sufficient Native American representation on those commissions, therefore reflecting the communities that will be affected by the redistricting lines drawn by the commissions?
Well, this round, I think there's a few Native Americans who are serving on redistricting commissions, and I think there's Native interests in Montana. Another state, I can't remember off the top of my head, but Arizona for the first time has a Native American on the commission. And I think that's really important because I think, as I explained in my materials, Native Americans have very rural areas across the country. They're some of the most rural areas, and they have unique needs that may not be understood by many of the people who live in urban areas. So to understand tribes and to understand the unique needs of tribal people, I think, is very important. And we've seen that commissions, at least this round, have included some Native Americans on their redistricting commissions.
Thank you. With regards to the San Juan litigation, how many elections took place during those 7 years that the case was being litigated?
Yeah, I'm sorry, I don't know off the top of my head, but I assume, I don't know off the top of my head how many elections took place during that time period.
But essentially, those elections took place with maps that were later found to be unlawful, and therefore Native Americans did not have the kind of representation for 7 years while laws were being passed. Mr. Vatamala, thank you so much for joining us today. Could you describe more fully how pre-clearance, as opposed to Section 2 litigation, impacts Asian Americans' access to the ballot?
Yeah, so as I mentioned, even in places like New York, we were able to successfully use Section 5 in a variety of ways in combination with Section 203. We used Section 5 to object, submit our objections to the DOJ when the New York City Board of Elections refused to transliterate Chinese ballots, the candidates' names. They refused to transliterate the candidates' names on the ballot. And we were able to use Section 5 to require them to do that transliteration, fully translate the ballot, and have 55,000 limited English proficient Chinese Americans able to vote. I also gave the example of Hubert Row in Texas, in that Texas House district. We would not have been able, we didn't have the resources to litigate under Section 2 for that seat, but under Section 5, the burden was on the state, right? And they were not able to carry that burden. And it was a great example of how Section 5 works well for communities with limited resources.
Gentleman's time has expired. At this time, the chair will recognize himself for 5 minutes, and I'll go back to Mr. Guatemala. U.S. Census data reflects that Asian Americans are the fastest growing racial group in the United States. Historically, we have seen that areas with significant growth in racial groups are also where there is greatest risk of discriminatory intent or discriminatory result in redistricting practices. How have these rapidly growing Asian American communities, many of which are in the South, been impacted by redistricting post-Shelby?
Yeah, so there is a backlash. You see it in some public comments by elected officials, which are included in our testimony. Asian American communities of interest, when we map them out and see where the boundaries are and do this exercise of superimposing those neighborhood boundaries over legislative lines, we see that in almost every instance, it's not a coincidence, in almost every instance, Asian American communities of interest are divided into numerous different districts, subverting this growth and thwarting the effects of this growth and the numbers to deny them the ability to elect a candidate of their choice. That's why the percentage of elected Asian American elected officials is not keeping track with that population growth. And we only see Asian American electoral representation when we have fair redistricting. Only then are they able to elect a candidate of choice, and they usually do.
Thank you. Thank you for that. Next, I'll address this to General Holder. General Holder, you were at DOJ at the time that Shelby County was handed down, and so you operated in two environments. You were involved in the pre-Shelby environment as well as the post-Shelby environment, and I know that must have been awkward for you as Attorney General. Section 5, as I recall in the court's decision, was found to be constitutional. That's what America needs to know. The Supreme Court of the United States found Section 5 to be constitutional. What was found to be unconstitutional was Section 4, which is the formula that gives life to Section 5. And so I know it must have been awkward for you at DOJ operating under the court's decision. And also I might recognize that the court, Chief Justice Roberts also acknowledged that voter discrimination continues to exist in the United States. And so that also is embedded in the court's opinion. And I recall I was a young voting rights attorney in North Carolina many years ago, back in the 1980s, and I practiced Section 5 law. President Reagan was president. William Bradford Reynolds, as I recall, was the chief of the civil rights section of the Department of Justice. And during the Reagan years, there were multiple Section 5 objections to election systems and to changes in election laws. And many, and let me defend some of the jurisdictions in the South that I'm familiar with. Many of these voting changes were not done specifically with the intent to discriminate against African-American voters, but they had a discriminatory effect. And so that's what the Department of Justice under President Reagan had to do. And the standard back then it continues to be the standard now. And I will read it again because I want America to know this. A state voting law has a discriminatory regressive effect if the law disproportionately and materially burdens minority voters when it's measured against pre-existing state law. And so my question to you, General Holder, is how did the Shelby decision affect your executing your duties at the Department of Justice when it was handed down?
Well, the biggest change was by taking away, in essence, taking away the pre-clearance ability, but you're right, because of the Section 4 problems. It stopped us from preventing negative things from occurring, as opposed to waiting for those negative things to occur and then trying to, make things better. It's almost as if you see somebody getting ready to set fire to a house. You can stop them and prevent the house from being damaged, as opposed to waiting for the fire to engulf the house and then trying to repair the house once the fire is put out. And so there are still parts of the Voting Rights Act that remain that are effective, Section 2, for instance, but that doesn't give the Justice Department all of the tools that it needs. And I really want to push back on the notion that somehow or other this was something only the Democratic attorneys general were focused on or made a priority. As you talk about, the Reagan Justice Department, the Bush Justice Department, I might not agree with all that they did, but they made a priority, the enforcement of the Voting Rights Act. Maybe I would say they didn't go far enough, but certainly they did things consistent with the intent of the act to protect the sanctity of our electoral system, using the tools that they had.
Thank you. Thank you for that clarification. And what my colleagues need to know, not those on this committee because they already know it, but the colleagues throughout the House, is that Section 5 is an administrative procedure. It is streamlined. It can be completed in 60 days. There's no cost associated with it. The covered jurisdiction need only to submit in writing the proposed change to the Department of Justice for an evaluation as to whether or not it's retrogressive. If DOJ says it's not retrogressive, it goes into effect. DOJ says it's not that it is retrogressive, it does not go into effect, and the jurisdiction then goes back and rewrites the law. And oftentimes, the rewriting of the law is done with consultation with DOJ. And I will conclude by mentioning Rocky Mount, North Carolina, in my district. When I was a voting rights attorney, the city wanted to annex 12 or 13 acres of land within the municipal boundaries. The city didn't realize the effect that it would have on minority voting strength in the community. It was about economic development. They wanted to get a shopping center into the city, and they wanted to annex. And once DOJ expressed an objection to the annexation, that's when the city asked DOJ, well, what can we do to make it right? And DOJ said, well, if you create single-member districts, that will kind of level the playing field. And the city said, you've got it. We're going to create single-member districts. They did it, and now it's 30 years later, and all things are well in that jurisdiction. That's the power of Section 5. It prevents the problem. Thank you for your tolerance. At this time, I will recognize Mr. Laudermilk. Welcome back, Barry. You're recognized for 5 minutes.
Well, thank you, Mr. Chairman. I appreciate you allowing me to participate in this, even though I'm not an official member of this subcommittee, and I apologize, I had to step out as things go here. We had some conflicting meetings, especially now as we're opening up and people are coming to meet with us in person. So I appreciate your indulgence. Look, voter IDs laws have been a huge topic since the 2020 election. In Georgia, they've been a big topic for many years. I was in the state legislature when we first adopted a clear and concise voter ID law. And it has been debated, but did find bipartisan support there. And despite of what some of the witnesses here and some others may believe, that voter ID laws are very popular and really an important safeguard for election integrity and the confidence of voters in election process. Most everyone has probably heard of the latest polls that have been coming out. Just this week, Monmouth University released polling data showing 80% of Americans support voter ID. And that did not surprise me in the least. Friends I have on both sides of the aisle think it's very important that you be able to prove who you are for something, or who you say you are, for something as important as choosing who the leaders of your school board, your city, your county, your state, your nation are. It has great implications, and it's an intricate part of being a secure election system. Even someone I served with in the state legislature kind of did surprise me of her statement, but Stacey Abrams has just recently said no one has ever objected to having to prove who you are to vote. Now, if my memory serves me correctly, that isn't the stance she took when we served in the legislature together regarding this matter. But I think we are starting to see a shift as people are seeing that this is very popular. among people because they want their vote to be protected. Attorney General Holder, in your testimony, you referenced voter ID laws as one method that has been used to, I think, if I've got it right, strip Americans of their rights. In the light of polling information I just referenced, including among Democrats and comments like those from Ms. Abrams, I'm just wondering, have you changed your viewpoint on voter ID, and do you or do you not support it, and why?
What I oppose is the overly prescriptive way in which states, generally Republican states, have indicated that which is acceptable to prove that you are who you claim to be when you want to vote. If you expand the number of things that somebody can use to prove they are who they claim to be, I could support, voter ID. But when you have that problem in Texas, as was mentioned before, where carrying a gun and you have a photo ID, that's acceptable, but a state-issued photo ID for a student is not. I've got problems with that. So if you come up with ways in which you make it widely available and you expand the number of ways in which people can prove that they are who they claim to be, yeah, I could see supporting, voter ID measures.
Well, that's good and refreshing to hear. In Georgia, if you don't receive a driver's license, you can get a free state-issued ID. And so anyone can receive the ID and can be used as identification for voting. Mr. Guatemala, do you support voter ID laws? And if so or not, why?
Yeah, no, we support reasonable voter ID laws, and it's really the same answer as Mr. Holder. It depends on what that list of acceptable documentation is.
Ms. Ferguson-Bonney, do you support voter ID laws, and what about tribal ID as a form of acceptable voter ID?
Thank you for that question. We have advocated for the use of tribal IDs when IDs are required. In some instances, they have not been accepted, or states have not accepted that as a form of ID, and that should be accepted as a form of ID. I'd like to note that the Navajo Nation, the largest tribe in the United States, does not issue a photo ID to their tribal members, and so that was concerning when Arizona passed their voter ID law, because it didn't take into account what types of ID that Native Americans may have. In addition, that because in rural areas and on reservations, a lot of areas, especially Arizona, other areas, people don't have traditional street addresses. And when they go to vote on election day, their addresses don't match because the counties change the addresses on the voter registration materials. And so that creates problems and sometimes results in votes not being counted.
Thank you. Continuing on the topic of voter ID, Mr. Hearn, you stated in your testimony that Democratic Virginia Attorney General Mark Herring appointed you to defend Virginia's election reform legislation against a constitutional challenge. That challenge included a voter ID requirement, correct?
That did, Congressman, and that was upheld by the Fourth Circuit. I would cite Virginia's voter ID law as a model of one that is constitutional, consistent with the Supreme Court's decision in Crawford. And I would also note, in terms of your state, the civil rights leader Andrew Young, former mayor of Atlanta, supports photo ID. And what we found at the Carter Baker Commission was that there was testimony that actually giving particularly minority members a photo ID for free increased their participation, because it gave them greater confidence that when they went into a polling place, they handed the ID over, they knew where they would be given a ballot that would be cast and counted. So it increased participation.
The gentleman's time has expired. All time has expired for this panel. We want to say thank you to all of our panelists. Thank you very much for your testimony, and thank you for your cooperation as we've tried to work through the technology. I think we've done reasonably well this morning, but thank you to the witnesses. We, in just a moment, will be moving to the second panel, but as they say in television, we will stop for a commercial break, and we will return in 2 or 3 minutes. The committee stands in recess until further call. Sines of the Mexican American Legal Defense and Educational Fund. Also, Janae Nelson of the NAACP Legal Defense and Educational Fund. Michael Waldman of the Brennan Center for Justice. Wade Henderson of the Leadership Conference for Civil and Human Rights. And Sarah Frankenstein of the law firm of Gunderson, Palmer, Nelson, and Ashmore in the state of South Dakota. Also, Thomas Sines is president and general counsel of the Mexican American Legal Defense and Educational Fund. We refer to it as MALDEF, where he leads the civil rights organization's offices in pursuing litigation, policy advocacy, and community education to promote the civil rights of Latinos living in the United States. He rejoined MALDEF in August of 2009 after 4 years as counsel to the mayor in Los Angeles, California. Janae Nelson. Janae is the Associate Director Counsel at the NAACP Legal Defense and Educational Fund. We call it LDF. Ms. Nelson is a member of LDF's litigation and policy teams and has served as interim director of LDF's Thurgood Marshall Institute and in various other leadership capacities at LDF. She was one of the lead counsels in Beasley versus Abbott, a successful federal challenge to Texas voter ID law. Mr. Waldman, who sits in front of me at this moment, is the president of the Brennan Center for Justice, which he has led since 2005. Mr. Walden is a constitutional lawyer. He's a writer and an expert on the presidency and American democracy. Mr. Waldman was director of speech writing for President Bill Clinton from 1995 to 1999, serving as assistant to the president. Wade Henderson, who I will acknowledge publicly is a friend, is the interim president and CEO of the Leadership Conference on Civil and Human Rights and the Leadership Conference Education Fund, an organization he previously led for more than 20 years. The Leadership Conference is the nation's premier civil and human rights coalition charged to promote and protect the civil and human rights of all persons in the United States. He recently retired as the University of the District of Columbia, David A. Clark School of Law, first Joseph Rao, Chair of Public Interest Law. That's a pretty long sentence, Mr. Henderson, but that's your experience. Next, Sarah Frankenstein is a partner at Gunderson, Palmer, Nelson, and Ashmore in Rapid City, South Dakota. She practices in the areas of civil litigation, civil rights, employment law, and election law, among other things. She is also the vice chair of the South Dakota State Advisory Committee to the U.S. Commission on Civil Rights. Again, thank you to the witnesses for your testimony today. We will now begin with Mr. Sines. You're recognized for 5 minutes.
Thank you. Good morning, Mr. Chair, honorable members. As president of MALDEF, I lead an organization that has for 53 years now worked to promote the civil rights of all Latinos living in the United States. Central to that mission has been our efforts over the years legislatively and in court to protect the voting rights of Latino citizens, the right of every Latino citizen to cast an effective vote. In the Latino community, since at least 1981, every year following a decennial census has been a year of great political opportunity, as each succeeding census has demonstrated the substantial growth and dispersion of the Latino community, including a growth in the Latino voting population. Absent some overwhelming and disparate undercount in the 2020 census, we expect a similar outcome from the 2020 census. Although we do not yet have the subpopulation data for the decennial census, the Census Bureau's own American Community Survey estimates show that Latinos accounted for just over half of the entire nation's population growth between 2010 and 2019. ACS data also estimates that Latinos made up over 44% of the entire nation's growth in citizen voting age population, a suitable proxy for eligible voters between 2009 and 2019. However, one consequence of this continued growth in the Latino community is that there is little question that the growth nationally of the Latino community and its potential voting impact is seen by some as a threat to their political power. This has had two major effects. First, it has resulted in Latinos becoming central to numerous false assertions, questioning the integrity of our elections. These false assertions with regard to the Latino community generally take the form of completely unsupported assertions that Latino immigrants who are not yet citizens are voting in substantial numbers. Political forces use these false assertions to back up onerous voting requirements that restrict the right to vote of Latinos and other populations. This includes new and more onerous voter identification requirements, new requirements to provide documented proof of citizenship in order to register, limitations on voter assistance in Spanish and other languages, attempts to proliferate in Spanish false information about the voting process, discriminatory targeting of in-person and absentee voters for challenge based on Latino surnames, and even in attempts to intimidate less experienced voters through the stationing of uniformed guards at polling places. But the second impact of this concern about the growth of Latino political power by some has taken the form of manipulations of our governance structures, including the perpetuation or reintroduction of at-large voting, or the failure to acknowledge and incorporate the growth of the Latino community in the decennial redistricting process. To give just two examples, following the Shelby County decision, the city of Pasadena, Texas decided to shift from 8 districted seats on its city council to 6 districted seats and 2 at-large seats. The sole purpose of this creation of 2 new at-large seats was to restrict and prevent the growing Latino voting population from electing a majority of the city council. With respect to redistricting, I give another example. Following the last census in 2011, MALDEF identified 8 counties in the state of California, my home state, that should have drawn an additional Latino majority district on their 5-member county board of supervisors, but failed to do so. Because of the arduous cost and effort involved in challenging this kind of discriminatory redistricting, through the course of the decade, we were only able to challenge, successfully I add, 1 jurisdiction, Kern County. The fact is that the challenges in the face of those who believe that the growth of Latino population is a threat to their political power are many. While the rigging of the system to embed the power of incumbent long-term office holders in the face of a newly ascendant population like the Latino population may be symptomatic of human nature, it cannot be characteristic of a thriving democracy. We cannot address this system only through litigation that is costly and inefficient. This is not a time to shrink from efforts to encourage broader participation of all eligible citizens in voting. Congressional action to preserve voting rights is essential as we commence redistricting and as we face the continued false evocation of phantom threats used to justify the targeting of all voters of color. At MALDEF, we call upon the Congress to take action to address this ongoing problem and ensure that the voting rights of all Americans can be preserved and expanded. Thank you.
And we thank you for your testimony. At this time, the chair will recognize Ms. Nelson for 5 minutes. Ms. Nelson.
Good morning. Thank you very much for allowing me to testify, Chair Butterfield, Ranking Members Steele and Davis, and members of the committee. My name is Janae Nelson, and I am the Associate Director Counsel at the NAACP Legal Defense and Educational Fund. Since our founding in 1940 by Thurgood Marshall, LDF has led the fight to secure, protect, and advance the rights of Black voters. Despite the guarantees of the 14th and 15th Amendments and the Voting Rights Act, however, racial discrimination and targeted suppression of Black voters persist. And in the infamous 2013 Supreme Court decision, Shelby County versus Holder, we saw the beginnings of voter suppression metastasize in our country. By disabling Section 5 of the Voting Rights Act, Shelby unleashed systematic attacks on the voting rights of racial and language minorities. Yet one of the solutions to this assault on our democracy lies in the very decision that instigated it. In writing for the 5-4 majority of the court, Chief Justice Roberts expressly invited Congress to update Section 5's pre-clearance formula to reflect modern conditions. For 8 years, though, Congress has failed to act, leaving voters of color under attack and leaving our democracy at risk. In LDF's report, Democracy Diminished: State and Local Threats to Voting Post-Shelby, we have maintained an ongoing catalog of the discriminatory voting changes in jurisdictions formerly protected by Section 5, changes that pre-clearance likely would have prevented. Without Section 5, we must now rely on case-by-case litigation under the Constitution and under another provision of the Voting Rights Act, Section 2, which has now become the primary statutory check on racial discrimination in voting. In fact, according to the U.S. Commission on Civil Rights, in the first 5 years following Shelby, an unprecedented 61 lawsuits were filed under Section 2 of the Voting Rights Act. 23 of these cases were successful. By contrast, in the 5 years before Shelby, only 5 Section 2 cases were won. This means that after Shelby, after Section 5 was disabled, the rate of successful Section 2 litigation quadrupled. And these cases arose predominantly in jurisdictions formerly covered by Section 5. I'll give you a few examples. In 2013, LDF sued the state of Texas to stop implementation of its discriminatory voter ID law, a law previously blocked by Section 5, which Texas revived within hours of the Shelby decision. That litigation produced multiple court findings that Texas's voter ID law violated Section 2, including a finding of intentional racial discrimination against Black and Latinx Texans. But by 2018, when the case concluded, thousands of voters have been disenfranchised in hundreds of state and local, federal elections. In 2016, the largely white city of Gardendale, Alabama, attempted to secede from the more racially diverse Jefferson County School Board, which would have transferred Black voters from a districted election system where they have some representation to an at-large system where they have no representation. The 11th Circuit blocked secession in 2018 after LDF successfully proved Gardendale was motivated by racial discrimination. In 2018, LDF also filed a suit on behalf of students at Prairie View A&M University, a historically Black university in Waller County, Texas. The county had refused to provide equal early voting access on the university's campus, even though students lack transportation and rely on early voting to access the franchise. That litigation is ongoing. In 2019, LDF and our allies sued to stop Florida from requiring people with past felony convictions to pay all fines and fees before registering to vote, a legislative overreach that contradicted the will of Florida voters in passing Amendment 4. However, the 11th Circuit reversed the district court's favorable ruling and blocked thousands of returning citizens from voting. In 2020 alone, we have filed 5 Section 2 cases. And this year, in 2021, we have filed 2 more challenging voter suppression bills in Georgia and in Florida. But as my colleagues have said, this case-by-case litigation is no match for this national democracy crisis. This year alone, at least 14 states have rolled back early and mail voting, added new hurdles for voter registration, imposed burdensome and unnecessary voter identification requirements, stripped power from state and local elections to enhance voting access, and taken other steps to make voting more difficult. Litigation is a blunt instrument. It is costly and slow. Victories typically come only after a law has been in place for several elections, irreparably harming countless voters. Pre-clearance is necessary because it blocks these discriminatory voting laws and changes. In fact, the recent wave of voter suppression bills would likely never have been introduced under pre-clearance. The deterrent effect was Section 5's genius. It stopped discrimination before the harm occurred. We urgently need that prophylactic legislation now. It is unacceptable that in 2021, 56 years after the VRA's passage, the right to vote remains so very underprotected. The celebrated turnout and registration rates among Black voters occurred despite a litany of unequal obstacles and because of Herculean efforts by civil rights groups, organizers, and activists, and Black voters' shared determination and resilience. This model is not sustainable, nor is it acceptable. We urge Congress.
I hate to break the news to you, but your time, you may complete the sentence.
Thank you. We urge Congress to safeguard the integrity of our democracy and fulfill the generations-long project of perfecting our union. Thank you very much for your time.
And thank you, Ms. Nelson. And would you please give my best regards to the LDF staff? I have a long-standing friendship and relationship with LDF. I get a lot of credit in North Carolina for voting rights litigation back in the 80s, but much of that credit is overrated. It was the Legal Defense Fund that led the way and financed the lawsuits and did all of the heavy lifting in those cases. So please give my regards to LDF. And I wrote down a few names that I recall during those days: Jack Greenberg, Napoleon Jones, Lonnie Guinier, Julius Chambers, Leslie Winter, Elaine Jones, Ted Shaw, and the list goes on. And all of those people would not have been possible without Charles Hamilton Houston and Thurgood Marshall. I just had to get that into the record because it's accurate. It is a fact. Thank you, thank you, thank you. At this time, the chair will recognize our next witness, and I guess that's going to be Mr. Waldman. You recognize for 5 minutes.
Thank you, Chairperson Butterfield, Ranking Member Stile, members of the subcommittee. Thank you for the opportunity to be here with you at this hearing. This is a critical moment for our democracy and a critical aspect of the fight for our democracy. As you all know, the Voting Rights Act was perhaps the most effective civil rights law our nation has ever had, vital to the drive for a vibrant multiracial democracy in our country. As you know, 8 years ago, the U.S. Supreme Court gutted the most effective part of that law. Members of Congress of both parties have the power and the duty to right that wrong, to modernize the Voting Rights Act and strengthen it to defend our democracy so all Americans can vote. I want to make 3 points building on the testimony that others have said. First of all, as we've just heard, for the past 8 years, the absence of preclearance, the absence of a strong Voting Rights Act, opened the way for racially discriminatory voting rules and practices across the country. For example, voter purges, removing voters from the rolls, can be appropriate, or it can remove eligible voters. We found in Brennan Center research that voter purge rates soared in the states that previously had been covered by Section 5 of the Voting Rights Act, preclearance, 40% higher than the rest of the country. All told, 17 million people nationwide removed from the rolls in just 2 years. We've seen polling place closures and all kinds of other activities around the country that have been described and documented. And now, in the wake of the 2020 election, the absence of a strong Voting Rights Act has opened the way for the attack on voting that is taking place right now in the states. We keep track of this. As of May 14th of this year, lawmakers in states had introduced more than 389 bills in 48 states that one way or another would curb the vote or restrict voting. And I should note that these are not backbenchers throwing a bill in the hopper to get a good few hours on Twitter. These are bills that are passing and becoming law. 17 states have enacted new laws that in one way or another restrict access to voting. And these laws often uncannily target voters of color. And again, were the Voting Rights Act in full effect, were preclearance in full effect, these laws would be scrutinized, many would be blocked, many would be blunted. The second point I want to make is that these racially discriminatory laws are based on a lie. American elections are secure and accountable. Voter fraud in the United States is vanishingly rare. You are, as has been noted many times, more likely to be struck by lightning than to commit in-person voter impersonation in this country. And contrary to the big lie about the 2020 election, it was extraordinarily well run, as confirmed by the Department of Homeland Security, as confirmed by 60 courts, as confirmed by the Justice Department under President Trump. And I will note that this week, the Republican legislature in Michigan put out a report confirming there was no substantial voter fraud there, and the election was well run there. Yet this is a lie that justifies a conspiracy theory that provides the pretext for discriminatory voting laws being pushed and passed all over the country. And I should note again, the racial subtext, unfortunately, is rarely far from the surface. When former President Trump targeted and called out and sought the removal of the effective votes from voters in Detroit, in Philadelphia, in Milwaukee, in Atlanta, it wasn't very subtle what the implications of that were. All the more reason why a conspiracy theory should not be allowed to deny people the right to vote, and why Congress and members of both parties can once again protect that right to vote with a strong Voting Rights Act. I'll note finally, as a third point, that it is important that this legislation be understood to work in tandem with the For the People Act, with H.R. 1, which has already passed the House of Representatives. Both are vital, both are needed. The John Lewis Voting Rights Advancement Act, in effect, is forward-looking. It deals with preclearance for future legislative proposals. The H.R. 1 would set national standards for elections and deal, including laws that have been passed right now. Both are constitutional, both are well-crafted, both are needed. We urge the support of Congress for both of them. Finally, as you know, John Lewis' name is on this bill. He gave so much of his blood and of his own soul and courage to bring the Voting Rights Act into effect. Members of both parties over many decades were together in this effort. We urge you to once again carry forward his legacy, carry forward his name by strengthening, modernizing this vital piece of American law. Thank you.
And thank you. It should be noted that the John Lewis Voting Rights Advancement Act has not been introduced because we have not completed these hearings, but as soon as we can finish all 16 of our hearings among the three committees, it is our sincere hope that it will be filed very quickly, and we're hoping that it will be given the label HR 4, and hopefully we can decide it and send it over to the Senate for its approval. Mr. Henderson, you're recognized for 5 minutes.
Thank you, Chairman Butterfield, Ranking Member Stile, and members of the subcommittee. Good morning. And thank you for this opportunity. And thank you, Chairman Butterfield, for your leadership in calling these critically important hearings on how we ensure that all of us, no matter our color, zip code, or income, have an equal say in our democracy. In his final message to the nation, the late Congressman John Lewis left his marching orders. He called on us to remember that, quote, democracy is not a state, it is an act. He said that every generation must do its part to build the beloved community. I'm deeply heartened that Americans are heeding his call. Across diverse backgrounds, amid a pandemic, people turned out to vote in unprecedented numbers. It was an awe-inspiring moment for the world's oldest and greatest democracy, and a declaration of the possibility to realize our highest ideals. Indeed, voting is the language of democracy. Some lawmakers, however, have turned their backs on the Congressman's noble call. They are trying to take us backwards by creating barriers for Black, Brown, Indigenous, and new Americans who want to exercise their right to vote. Our nation is faced with reconciling the contradiction of who we say we are and who we actually are. Congress must swiftly set to make real the promise of democracy for all. We didn't get here overnight. 8 years ago tomorrow, the Supreme Court decided Shelby County versus Holder and decimated the heart of the Voting Rights Act. Section 5 allowed the Justice Department to block proposed discriminatory voting restrictions in places with pervasive histories of discrimination and ensured voting changes were public and transparent. Despite the best efforts of the Leadership Conference and our members to protect the franchise, nearly a decade of anti-voter tactics has exacerbated a harmful toll. Without the VRA's strongest tool to fight discrimination, lawmakers continue to wage a coordinated attack on Black and Brown voters. The deluge of anti-voter laws is unrelenting. Voters of color face intimidation, burdensome ID requirements, voter purges, and disenfranchisement laws built on top of mass incarceration. States cut back early voting, eliminated same-day voter registration, and shuttered polling places. In 2020, politicians exploited the pandemic by imposing additional barriers to the ballot. But democracy prevailed because the people prevailed. Voters refused to give up their power. This revealed not only the American people's resiliency, but also our collective will to ensure our democracy works for everyone. Yet the assault on our freedom to vote has only grown more dire. After historic turnout, politicians peddled lies, tried to discount the votes of communities of color, and attempted to override the will of the people. Their efforts ultimately fueled a deadly attack on this very institution by armed right-wing militants. Now they've doubled down on attempts to reshape the electorate for their own gain. Since January, state lawmakers have introduced, as my colleague Mr. Waldman said, 389 anti-voter bills and enacted 22 laws. These restrictions disproportionately burden voters of color. They resemble the very strategies that led Congress to adopt the Voting Rights Act in the first place. In her dissenting opinion in Shelby County, the late Justice Ruth Bader Ginsburg wrote that throwing out preclearance when it successfully stops discrimination is, quote, like throwing away your umbrella in a rainstorm because you're not getting wet. Today, we are drenched. This is our moment to act. Right now, we have no other choice if we want to fulfill the promise of our democracy, that every voice and every vote count. Congress must pass the John Lewis Voting Rights Advancement Act and restore the VRA to its full strength. Shortly before President Johnson signed the VRA into law, 25-year-old John Lewis led more than 600 people across the Edmund Pettus Bridge. State troopers unleashed brutal violence, and our hero was beaten and bloodied. But he never gave up the fight. For decades, he implored his colleagues in these hallowed halls to realize equal opportunity for all. Before his death, he wrote, and I quote, "Time is of the essence to preserve the integrity and promises of our democracy. Members of Congress must now answer his call with all the force you can muster." Thank you for allowing me to testify this morning.
And thank you, Mr. Henderson. This time, the chair will recognize Ms. Frankenstein. Some may pronounce it Frankenstein, but I say Frankenstein. You are now recognized for 5 minutes.
Thank you, Chairman Butterfield, Ranking Member Stile, Ranking Member Davis, and members of the committee. My name is Sarah Frankenstein, and I'm a private practice attorney in Rapid City, South Dakota. I practice voting rights and election law and advise election administrators in the Midwest in all aspects of elections and voting rights. I was lead counsel in numerous Federal Voting Rights Act cases and other election disputes, including redistricting and felon voting issues. These matters often involve issues unique to American Indian voting, as well as tribal and county governmental concerns. I'm presenting information on 2 areas of Voting Rights Act litigation relevant to American Indian populations within states and counties. The first is the issue of preclearance, where in South Dakota previously had 2 counties which were deemed covered jurisdictions in 1975. South Dakota's 2 counties previously covered were not added, excuse me, initially, but after additional tests were promulgated in 1972, which found that counties should be added to the preclearance list if they maintained a test or device which included holding elections in English, and the county had less than 50% of voting age citizens registered to vote, did in fact vote in the November 1972 election. In 1975, 2 counties in my state of South Dakota were added as covered jurisdictions. In 1977, our then South Dakota Attorney General determined that the preclearance requirements were an unworkable solution to a non-existent problem and advised that the state should not seek preclearance for those laws while he pursued litigation to exempt South Dakota from the VRA preclearance requirements. What that did was create a backlog of 3,048 South Dakota laws that needed to be submitted for preclearance once the state and actually the 2 counties that were covered were sued for that very purpose. I think that this scenario, excuse me, would present the very method to uncover discriminatory or retrogressive statutes, administrative rules, and other laws that were passed by a legislature over 25 years when its legislators had no threat or no feasible threat hanging over their heads because they understood that they did not need to seek clearance for these laws. One might expect that a number of these 3,000 plus laws would be found objectionable or otherwise denied preclearance. How many of South Dakota's 3,048 laws and administrative rules were denied preclearance? None. Such facts are a strong indicator that preclearance is not needed in South Dakota. Are our individual counties should they be subject once again to preclearance requirements? In my experience, including in representing these counties themselves, they are often reservation counties, as I say. Reservations make up the majority or maybe all of these counties. They're run by majority American Indian leaders. And in my experience, the American Indian leaders do not pass local ordinances that deny or abridge their own people's ability to vote. County election officials work with their respective tribes to find polling places, which are usually determined by the tribe. To give you an example of the burden that's placed upon these reservation counties when they're under preclearance is typically found in the issue of moving polling places. An example that I had representing a county was a tribe who had previously indicated a polling place could be located in a certain tribal building, indicated a few days before the election that in fact the county could not use that polling place, but offered up another tribal building that it found more suitable. I, on behalf of that reservation county, sought expedited preclearance from the Department of Justice. I did not get a response before the election. The county was placed in the situation of not knowing whether it should go forward with the new location, trying to hold an election in a place the tribe said it could not. Finally, after the election, we received preclearance being granted by the Department of Justice. It demonstrates the situation, however, when bureaucracy can move slowly, but yet we need to have certainty in how to run our elections back here in South Dakota. Second, redistricting hasn't been a recent issue. We've had no redistricting cases here in the last decade, but what we have seen are Voting Rights Act vote denial claims, particularly in light of the issue of satellite offices. Our county courthouses are not located on Indian trust land generally, so to engage in in-person absentee voting in a brick and mortar building, one needs to leave the reservation and travel to the county seat. Because that requires distance, transportation, et cetera, we have had success working with counties to implement HAVA funds, Help America Vote Act funds, in order to fund those types of offices. Now, efforts to require preclearance in these counties don't ameliorate or address those underlying funding problems in reservation counties.
Thank you for your testimony. That completes the testimonies of the witnesses. We will now move to member questions. Looks like my friend from California, Mr. Aguilar, will go first. Mr. Aguilar, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. Mr. Sines, in your testimony, you stated that congressional action or inaction today will have a critical impact on the enduring condition of our democracy 5 years from now. Can you explain how the failure of enacting comprehensive voting rights bill will affect generations to come?
Sure, I think it's grounded in the fact that litigation, which is still possible, primarily under Section 2 of the Voting Rights Act, is notoriously costly and inefficient. It means that as the challenges to voting rights proliferate, our ability, even with a reinvigorated Department of Justice Civil Rights Division, our ability to successfully challenge all of those depredations of voting rights is limited. That's when legislation is most necessary. The most important piece of that is to reintroduce preclearance as an operative tool to prevent the implementation of changes that restrict the rights of minorities to vote.
Could you also expand on how the Latino population is already feeling the impact from some of these attempts to seize control from individuals and eliminating their right to vote by using reduced methods? Mr. Waldman talked a little bit about that and the number of state measures that have proceeded. Can you talk about their impact to the Latino population?
Absolutely. Thank you, Congressmember. Because the Latino population is growing as quickly as it is, we have substantial numbers of new voters, and it is particularly new voters who are affected by these attempts to restrict the right to vote, whether that takes the form of requiring new voter registrants to provide proof of citizenship not required of their predecessors, or new restrictive voter ID provisions where voter ID is not readily and costlessly available to those new voters. So the impact on the Latino community as it expands and grows and produces more and more voters who turn 18 and become eligible to vote is substantial of all of these efforts to deter participation.
Thank you, Mr. Sines. Mr. Waldman, could you elaborate a little bit more and talk about some of the harm that you see in the near and distant future to marginalized communities and their ability to exercise their right to vote if some of these measures, the statewide measures, continue and we don't pass anything here?
Well, we've had measures that have passed and measures that are being considered. In Florida, for example, where 64% of the voters in an overwhelming bipartisan vote voted to end that state's notorious voter disenfranchisement regime, felony disenfranchisement regime for people with past criminal convictions, the legislature followed up by passing a requirement that changed that and made it so that you can only get your right to vote recognized if you had paid your fees and fines. This overwhelmingly has a disproportionate impact on voters of color because of the way the criminal justice system works. In many of the measures that we've seen advanced or moving or passed in states across the country in the past few months, they've targeted activities that voters of color are using, and sometimes recently, as was mentioned earlier, vote by mail, for example, was never particularly controversial. But when communities of color began to use that method during the pandemic very successfully, suddenly it became the target of efforts to cut back on vote by mail. Some have been rebuffed, some are moving forward, but there are ways in which you can trace the voting patterns and map it against these measures. And, as you know, in the last election, despite the pandemic and despite voter suppression and despite the lies, it was the highest voter turnout since 1900. We think we ought to be celebrating that and not trying to undo some of the changes that made that possible.
Thank you, Mr. Waldman. Back to you, Mr. Sines. Section 203 of the Voting Rights Act, talks about access to limited English proficient voters through language assistance. Many jurisdictions locally, we know, fall short of that through access of interpreters and other resources that are necessary. Can you talk a little bit about how states are failing to meet the needs of limited English proficient voters?
Sure. Well, failing to provide those resources required by Section 203 is the first barrier. It's often compounded when states or localities place limits, whether by law or in practice, on providing voter assistance to those who may need assistance in a language other than English. We, for example, at Maldiv are currently challenging a law in Arkansas that, in contravention of the Voting Rights Act, limits the number of voters who someone can assist when they need that assistance to cast an effective ballot. So we have failures to comply with 203, compounded by restrictions that contradict current law on assisting voters who need that assistance because they have challenges with language. And I should end, Congressman, by pointing out that all of this has a disparate impact, a discriminatory impact on our newly naturalized voters, who are folks that show by practice a greater inclination to participate in voting, but are restricted and prevented from doing that by these laws.
Thank you so much. My time is up. Mr. Chairman, yield back.
Thank you. Thank you. At this time, the chair will recognize the ranking member of the full committee. 5 minutes.
Thank you, Mr. Chair. Always good to follow my good friend, Mr. Aguilar, twice in one day. I couldn't ask for more fun, sir. Mr. Sines, I'd like to start with you. Why did Maldiv sue to prevent the new Illinois legislative map from going into effect?
We sued because the legislature, as you know, used ACS figures instead of decennial census figures. I do want to make clear that neither our clients nor Maldiv seeks to change the legislature's ability to draw the lines. As you know, there's a state constitutional provision that could shift that responsibility from the legislature to a commission. But it appears clear to me that it was not the intent of that provision to shift that responsibility based on the happenstance of a delay in the release of decennial census data. So all we seek in that lawsuit is to have the lines redrawn using decennial census data once that data is made available by the Bureau later this summer.
Well, aside from the clear constitutional issues, sir, why is it important that states like Illinois use census data instead of population estimates when drawing maps, as you just briefly talked about your lawsuit doing?
Sure. Thank you, Congressman. The reason is that the census is an actual enumeration, as you know, from household questionnaires of our entire population, whereas the ACS is estimate data based on a sample of households across the country. Because it is a limited sample, the Census Bureau does not provide numbers except over a 3 or 5 year average. So if you redistrict using ACS data, you're actually looking at population estimates that go back to 2015, rather than data from the decennial census that is from 2020. So among other problems, it is outdated data if it's used to redraw our lines.
Sir, as you know, the Chicago area has grown in Latino voting age populations exponentially over the last decade. Do you and your organization support drawing another Hispanic majority district in the Chicago area?
We support it if the census data indicates that an effective district that would allow Latino voters to elect a candidate of choice can be drawn. That's something we can't assess completely until we have that decennial census data, but certainly it has long been our goal, particularly in a context, as you've indicated, in Illinois. The Latino community is growing while the whole state's population is shrinking. In fact, as you know, the apportionment data shows that the state's population did shrink over the last decade, but we know from ACS estimates that the Latino population in Illinois grew by over 100,000 or more people. So if it is possible to draw another effective Latino majority district, we certainly would be in favor of that.
Great. I've been working with you because I think we know that the only thing that would stop another Hispanic district from being drawn would be pure partisan politics. Ms. Frankenstein, can you speak to the committee about particular federal impediments you have identified that may reduce the number of Native Americans who cast ballots in federal elections?
One issue is the popular area of vote denial claims for lack of satellite offices on reservations. I can tell you that working with my clients who are elected county officials, regardless of their race, whether they're majority white, whether they're majority American Indian, or all American Indian county commissioners, they all face the same concern, and that is lack of funding for such offices and lack of space, buildings to actually locate those. Where we have found success, however, is where we are able to utilize HAVA funds in order to hire, train, and staff those offices and pay a lease agreement in order to fund those. I do not believe that pre-clearance requirements would help in this regard in any way, but it is necessary that we allow or we provide funding through HAVA or otherwise to those cash-strapped counties. Our reservation counties are funded through property taxes, and land held in trust does not contribute to the property tax base. So the very counties which have more American Indian population have less money to work with. Those are the counties that are sued, requesting satellite offices, and they don't have the funds to create those offices. So I would encourage more of a focus on funding to allow those capabilities in those counties, and less focus on pre-clearance requirements for those cash-strapped counties.
Great. Are there any rural mail delivery issues that are part of this?
There can be. In our reservation areas, oftentimes they lack a post office or one nearby. It's common for a family, for large groups and large families to live together and share a mailbox. There are concerns among Native American voters as to how to get their ballot to the mailbox or to the post office, and they tend not to trust the postal system. Therefore, they more heavily rely upon election day voting and in-person absentee voting.
Great. I see my time has expired. Thank you to the witnesses, and thank you, Mr. Chair. I yield back.
And thank you, Mr. Davis. At this time, the chair recognizes the gentlelady from New Mexico, Ms. Ledger Fernandez.
Thank you, Mr. Chairman.
Yeah.
You know, the witness testimony today and in our earlier hearings laid out multiple examples of how after the Shelby County decisions, communities were forced to bring Section 2 cases as states formerly under preclearance immediately passed laws, or recently as well, to restrict Asian Americans, Latinos, Native Americans, Black Americans' access to polls and their ability to elect candidates of their choice. They won, right? They won those lawsuits, many of those lawsuits, proving that gerrymandering and changes in laws and procedures were unlawful. In contrast to, as Mr. Waldman noted, the big lie that there has been fraud in elections, which I note the courts have rejected. The courts have found that voting discrimination is real and still happening. Mr. Sines, it's great to see you again. Mr. Sines was the Vice President of Litigation at MALDEF when I was on the board, so I appreciate having the opportunity to ask him questions again. Your written testimony noted that it took a decade of litigation to address Texas legislators splitting Latinos after primarily Latino population growth gave Texas 4 new districts. We heard earlier today of a 7-year battle by the Navajo Nation in Utah. What are the policy consequences for the community when election after elections occurs under a system that has deprived Latino voters of the right to vote or elect a representative of their choice?
Thank you, Congressmember. Great to see you there. As you know from your experience with Section 2 litigation, the consequence is the elections that go forward under flawed discriminatory systems undermine confidence in our democracy, because a court later proclaims that elections occurred under districts that should not have been drawn the way they were. It means that folks were deprived of representation that reflects their views over a significant period of time. I should note that that Texas litigation did last 8 years. Fortunately, there were interim maps put in place, but those interim maps did not reflect all of the changes ultimately required by a case that went to the United States Supreme Court twice over the course of those 8 years. So even in that system with an interim map in place that addressed some of the problems, all of the problems ultimately identified by the 3-judge court were not addressed by those interim maps. And the biggest problem, as you also know from your experience, is that Section 2 litigation is costly. It means that organizations like MALDEF, and there were many others involved in that Texas litigation, that our efforts are diverted from our ability to challenge other deprivations of right in other parts of the country.
Yes, and in Section 2 cases, we also must prove and do prove that the failure to have representation often leads to policies, legislative policies that don't assist those particular communities. So they are the harm is compounded and compounded. Mr. Henderson, some of my colleagues have cited the record voter 2020 turnout as evidence that voter suppression is not an issue. What's your response to this?
Well, thank you for the question, Congresswoman. We have seen in a number of jurisdictions that notwithstanding the extraordinary turnout by voters of color, and I'll cite one example, Milwaukee, Wisconsin. In the primary of 2020, Milwaukee had previously 180 polling places that were reduced to 5. That meant that voters, even with an expanded population, were compressed into casting a vote in a narrower group of eligible precincts. That meant that in many instances, lines of 4 and 5 hours in length were required in order for an individual to cast a vote. Now, this was at a time when the county in which Milwaukee sat was a hotbed of COVID pandemic development. And in fact, I believe in my testimony, I cite the fact that the county had, I believe, the highest death rate of African-American voters at all. And so what we see in county after county is, notwithstanding the increase in voters, there has often been an effort to winnow down the number of places that voters could cast ballots. And that meant, of course, they were faced with the prospect of long lines under difficult circumstances in trying to cast their ballot. And we have only now begun to really assess that for its true impact.
Thank you, Mr. Henderson. In New Mexico, we saw some of those lines, and in H.R. 1, we have provided that there is a 30-minute time limit by which all voters should be able to cast their ballots. Mr. Chairman, my time has expired and I yield back.
Thank you. The gentleman from Wisconsin. I don't know, you're not from Milwaukee, but you're from the state of Wisconsin.
I have the great honor of representing part of Milwaukee County. But
you do?
From Wisconsin. From
all right. You're recognized for rebuttal. Yes.
I'm actually going to be adding on to the comments. I don't know that this will be a full rebuttal. Before I dive in, I'd like to just insert to the record, if I can, 2 articles. One, a Journal Sentinel article titled "Eric Holder Addresses Wisconsin Redistricting Panel prompting criticism, and another article titled Washington Post denounces report on Stacey Abrams' Dem evolution of voter ID.
Both articles, without objection, will be received.
Mr. Henderson, I appreciate you bringing up the case of Milwaukee. I think it's actually really important. I don't think everybody fully appreciates how the spring election in Milwaukee played out, how it played out very differently than other cities across the state of Wisconsin during the spring 2020 election. Milwaukee, correctly, as you noted, did reduce the number of polling locations, and is correctly identified by my colleague here, from 180 to 5. I think that's a pretty important point to recognize. Do you know who appoints the elections administrator in the city of Milwaukee?
I do not.
It's a worthwhile point, because I think it would enhance your written testimony. It's the Democratic mayor of Milwaukee, Tom Barrett. It's also worth noting, and it's kind of interesting, at that election, he was actually running in a primary for the election for mayor against a African-American woman. And so I think it's worth noting, and I think it's actually interesting, the last time Republicans held the mayorship of Milwaukee, the city, is 1908. And the last time anyone held besides a Democrat was actually 1960, and it was a socialist. So it went from Republican to socialist to Democrat, and it's been held by Democrats since 1960. And so while I share some of your concerns about what played out, I think it's very worthwhile for this committee to recognize that it was under a period of time of Democratic control, and it was a Democratic appointee that made the decision to reduce the number of polling locations from 180 to 5. And meanwhile, 70 miles away to the west, another very liberal city, Madison, Wisconsin, actually only reduced their polling locations from 92 to 66. Yes. So in an area that was disproportionately African-American in the city of Milwaukee, a Democratic appointed elections official made that decision. I think your testimony is spot on, but I think it could be enhanced by noting some of that background. I hope you have the opportunity to look into it.
Mr. Stile, may I respond? Because I think you're making a point that my organization emphasizes regularly. We are a nonpartisan organization. We operate under the view that voting really is the language of democracy. It is not a partisan issue. It is a national issue. And regardless of who is in control, the evidence that you cited and that I cited is evidence of the fact that the voting laws need to be enhanced and protected for all. Obviously, there are.
Let me reclaim my time. I wanted to give you the moment to reply, and I appreciate it. I think we do share that, is that we're enforcing the laws on the books. I think that's a very important point, that we're not changing the rules of the road as we go. But if I went back to your testimony, you noted that the Republican majority in the state refused to give people a few extra days to return in their mail-in ballots, which I think actually would change the rules of the road as we go, because voting was ongoing at a period of time where you would look to then change the rules.
But I would argue that the pandemic clearly was an intervening factor that warranted a review of the voting procedures to determine whether amendments were necessary. Certainly, no one would argue that as the country was battling the height of the pandemic and that people were dying at amazing rates, that we should not have taken a closer look at how we exercised in-person voting.
I think we definitely should have taken a look. I think changing the rules of the road while voting is ongoing is a very dangerous path to go down. But let's pause that. Let me shift gears to Ms. Frankenstein, if I can. Chief Justice Roberts in the Shelby case quoted as saying that a lot has changed since 1975. And while racial discrimination and any racial discrimination in voting is too much, Congress must ensure that the legislation it passes speaks to current conditions. And so recognizing that the voting access for minorities in 1964 and 1965 was very different than it is today in 2021, and that thankfully we've made a lot of progress in righting historical wrongs, is a pre-clearance formula necessary in your opinion, Ms. Frankenstein?
In my opinion, it is not. I've cited to you the statistics of South Dakota and those laws that sought preclearance in our previously covered counties. As you heard me testify earlier, none were not granted preclearance. I think it's also an antiquated concept to look instead at whether ballots are offered in an indigenous language if you don't also look to whether or not the tribe in the respective county holds its tribal elections using its indigenous language.
Only because we're short on time. I'd love you to be able to keep going. I'm short on time. I'm recognizing the time. And Mr. Chairman, I yield back.
Mr. Style, did you yield back?
I did yield back.
Thank you, and thank you very much for your statements. The chair will now recognize himself for 5 minutes, and I will start with Ms. Nelson. Ms. Nelson, I know LDF has been collecting information and data for as long as I can remember, and probably before I was born. It's been a data collection agency as well as a litigating agency. Have you been collecting information since the Shelby County decision? And I know we don't have the time for you to recite it verse after verse, but can you give us a summary of what the record shows based on the information you've collected since 2013?
Absolutely. The Legal Defense Fund has a report that we admitted into the record. It's called Democracy Diminished: State and Local Threats to Voting Post-Shelby County, Alabama versus Holder. And in that report, we maintain an ongoing catalog of the discriminatory voting changes in jurisdictions that were formerly protected by Section 5. And we submit that these are voting changes that would likely have been prevented had Section 5 still been in place. What we've seen over time is that there's been a proliferation of laws across the country that otherwise would have never come to see the light of day, would have never infringed on voters' rights had Section 5 been in place. We know this because immediately after this Shelby County decision, in places like Texas and Alabama and other covered jurisdictions, those election officials resurrected laws that had been prohibited from going into effect by Section 5.
You publish voting changes on your website. Have you released
We do.
them?
They're on our website and they're
that.
routinely updated.
All right. So any citizen can go to your website or to the Brennan Center website and look at those changes.
That's correct.
All right. Let me just change gears, and the time goes so fast when you have the microphone. You know, during the Juneteenth debate a few weeks ago, Congressman Jim Clyburn of South Carolina said one of our greatest shortcomings here in Congress is that we fail to communicate. And I think, you know, when I go into my district and I talk about Section 5 and Section 2 and the importance of the Voting Rights Act, oftentimes, you know, those who are doubtful, you know, would ask the question, why is it necessary to have a large number of African Americans or Hispanic Americans in an electoral district? Why is that important? And sometimes that gets me back on my heels when I get the question asked, because the response to that is so basic and it's so clear. It's called racially polarized voting. The fact of the matter is, in many places throughout the country, and it's not in every community, but in many places throughout the country, a lot of voters vote along racial lines, regardless of the qualifications of the candidate or the preferences of the community, which means that if African Americans are a minority within a community, then the majority, if they vote along racial lines, that inherently discriminates against a minority group. And when you explain that and communicate that to individuals, they begin to see what this is all about. The other thing that people confuse is Section 2 vis-a-vis Section 5. Section 2 is very expensive. I recall back in the 1980s, Mr. Wallman, Mr. Henderson, it cost hundreds of thousands of dollars, and I suspect it's in the millions now, to litigate a Section 2 claim, not to mention the fact that it could take months or years to do so. I had a Section 2 claim in 1982 that it was not until 85 when it was finally decided by the court. And so it's very expensive and it's very time consuming. And the standard of proof in a Section 2 claim is not only intentional discrimination, but in 1982, Congress changed the law to a lower standard, which is discriminatory result. And so that's the standard that you are guided by in Section 2. Section 5 is so much different. That is a retrogression standard. You simply take the proposed change, you compare it to existing law, and see if there's any retrogression in the effect that it has on minority voters. Have I said anything, Mr. Wallman, that you disagree with? Yeah.
No, I think you stated it very well. And again, when Section 5 was in effect, it was a predictable regime that counties and states all across the country handled without much muss or fuss. It was a step forward for the country, and it was something that everybody was able to deal with. And what is needed now is in effect to modernize the coverage formula so that can work again.
You know, my first Section 5 claim was in 1982. I still have the records from it. I'm writing my book now, and so I had to refer to it the other day. In 1982, I complained about staggered terms. My county commission going from an at-large system to staggered terms. And DOJ took it up. They evaluated it for 60 days. They asked for more information. The county provided more information, and DOJ approved it. And then after another change that took place, we finally litigated under Section 2, and we won the case. County was divided into 7 districts, and now instead of an all-white board of commissioners, we have 3 African Americans, 4 white Americans, and everything is reasonably well. I'm not going to say it's perfect, but it's reasonably well. And so the Voting Rights Act is a very serious piece of legislation that is deserving of our attention. It protects democracy. And Mr. Henderson, you made a statement a minute ago that it is what for our democracy? It is the language, did you say, of our democracy? May I adopt that as one of my talking points? I like that. It is the language of our democracy. And so thank both of you, thank all of you for your testimony. Do we have any other members who have returned to the meeting? Yes.
Just a point of clarification, Mr. Chairman.
Yes.
I know I speak on behalf of the committee members. We just want to know if we're going to get an advanced copy of your book, and if you can, write a. I know Mr. Stile and Mr. Davis would really appreciate it.
Well, I've been writing.
I have a lot to learn.
It is quite the story.
I've been writing this thing, I want you to know, for many years now, and finally my editor told me a few months ago that I really needed to separate it into 2 books. One book on community history. Mr. Henderson's second cousin, who is also a local historian in my hometown. She and I are the local historians, and so I've been advised to separate what they call community history from memoirs. And so now instead of 1 book, it's now going to be 2 books. But anyway, just for public recognition, Mr. Henderson's second cousin is named Lisa Y. Henderson, who is from Wilson, North Carolina, but lives in Atlanta, Georgia. She's a real scholar. So thank all of you. Thank all of you. Is there any other business to come before the subcommittee before we adjourn? Yeah. All right. I have some housekeeping matters that we need to attend to. I ask unanimous consent. Is this it? Sure. I ask unanimous consent that we enter the following articles in the record from Mother Jones. It is entitled "The Dog That Voted and Other Election Fraud Yarns, the GOP 10-Year Campaign to Gin Up Voter Fraud Hysteria and Bring Back Jim Crow at the Ballot Box," end of quote. The next is from the Free Press of Ohio. It is entitled "Ohio, the DOJ Scandal and the Thor, the God of Voter Suppression." Okay, the third is from, you have to appreciate our staffs on both sides of the aisle. They work hard. The third and final one is from the Daily Cost, quote, "The 198th Thor, GOP voter fraud lawyer, Thor Hearn." I'm going to stop right there. Without objection, these 3 will be included in the record. Okay. Before we conclude, I'm going to ask also unanimous consent to enter into the record the report prepared by this subcommittee in the last Congress under then Chair Marcia Fudge, detailing our findings of discrimination in voting practices. That's the document that I hold in my hand. Hearing no objection, it is so ordered. If I'm not mistaken, and staff can correct me if I'm wrong, this is the hearing number 6 of 6, and this is 5 of 6. 5 of 5. This is hearing 5 of 5, and I think we're going to be completing this work, and we're going to be documenting and writing up our findings, and I will be transferring this data and this information to the Committee on the Judiciary, hopefully by June the 30th. That is my self-imposed deadline. That is my intention. And then we will await action by the Committee on the Judiciary, both in the House and in the Senate. And hopefully within the foreseeable future, we will be able to write a formula, write a bill, and get it passed and signed by the President. Thank you very much for your testimony. The subcommittee adjourns.